Morning, Rhonda. Morning, Rhonda. How are you? I hope yesterday went well, Rhonda, for you. Thank God it's Friday, you're right. Oh my days. Hang on, let me start the chat up. Sign into chat. I will sign into chat. Right, I'm in chat. Go Pat. I know I'm nervous, Rhonda, but I'm excited about the Pats. Why is this not working? Let me refresh this. Hang on, 2 seconds. Ah, fuck. It won't connect. Bollocks. Okay, I'll have chat open some other way. Hello, Just Jugs. Hello to you, my darling. How are you? I'm just trying to get through this before Lady Di appears, because that bitch gets on my tits a little bit. So, hey, Lady Di, how are you? I'm just saying how much I love you, how much I look forward to seeing you here today. How are you? As I say, hopefully, Rhonda, she probably not here now, but hopefully, Rhonda, the doctors went well yesterday, my darling. Everything crossed for you. Right, they're supposed to start at 8:30, but let me see if it's in the stream. The Law Crime has not gone live anyway, so they are not live. Let me just do this to see if there's anybody else that's gone live, as in, oops, wrong button. That's not good. I was just thinking, am I muted? No, I'm not. So, which is fine, which is good. So got that. Obviously, oh shit, no, wrong one. That's why. Okay, I need to change channels. That's why. View your channel. Okay. Hello. Right, let me switch this. Go to your switch accounts. I will switch accounts. Thank you. Also, corner. I know he gets excited when I show up, and where the fuck is everyone? Hello and welcome everyone. But Sarah P is fucking lazy bitch today. Look at her. She's not even here yet. Don't tell her, but I love Sarah P. But we won't tell her that though. No need to tell Sarah P that. Right, let me find to see if there's anything else. Hello, James. How are you, sir? How are you? Hope you're doing well, sir. I was thinking about you last night, James. Not in a raunchy way, but in a passive way. Because I was wondering, because I believe that you probably think this defendant's guilty. I have a vibe, but it's weird because not everybody, but the majority of Twitter and LawTube are all disgusted and think that he's innocent. So, and I always think of you. I don't always think of you. I thought about you. There, hang on. I'm trying to find. There, is that the Muppet Show? No, I don't remember what it's for. I don't remember what it's for. Morning, Robin G. How are you, Robin G? Hope you're doing well. I had that vibe to the land. Get out of my head. I know. Right. Let me see if there's anything live about this then. No, nothing. No court live at all about it. Okay. We'll just wait. They were supposed to go live. This is what they do though. They do this every stream. They all start late for some reason. So I don't know why they do that. And I haven't got a chat there. That sucks. Hello, Sasmas. How are you, my darling? Hope you're well. I hope you're well. Guilty or not? No, I'm just interested if you thought he was guilty or not. I don't know if you are. I just had the vibe that you thought. I thought his lawyer was really hurting his case. Yeah, I think that might be it, James. That might be it. It was more of a, I wasn't sure if it's a lawyer or whether he just thought he's done it. I don't know. I had that feeling yesterday, or was it the day before? I don't know why, but I just had a feeling that you'd already thought he was guilty of it, which is totally fine. That's up to you. Do you know what I mean? I wasn't judging you, by the way, and I hope you know that I wouldn't judge you anyway. Even though I do judge Scottish people that wear kilts and stuff like that. But do you know what? I don't 100% disagree with you about his lawyer hurting his case. I think the judge obviously hates him, and he has to understand that. He has to understand that the judge hates him. And I think yesterday he did change his tone a little bit, and so did the judge. But he's got to remember about the defender, his client. As much as we scream and shout, the judge's a bitch, the defendant's there sitting through all this. So we can get on with our lives afterwards. He can't. So my gut feeling says he's guilty, but I'll see how he plays out. That's fair. And that's why, my gut says he's not currently, but there's still a long way to go. There's still stuff that they need to show me. Show me the money. I'm interested to see how they can prove that he killed her. There's one thing to say that his DNA was there, but what's that got to do with killing her? Only because, there's many ways the DNA can get on her, whether he RA'd her or whether he actually had an affair with her or whatever. So I know I got lots of questions. Just because someone's DNA is on there does not mean they're the killer or anything. So that's where I'm at anyway. Only just ladies in the chat, I know. James says, I'll see how it plays. I know you will. As I say, I wasn't trying to call you out. I hope you don't think I was calling you out. I was calling you out, but not in a bad way. I think you can take it as in you were just my example. The fact I was even thinking about you on a night, that says more about me than you. Fuck, thinking about James in the night. No, but I appreciate everyone's opinions. Right, court has just... Here we go, court's here.
Mr. Cruz?
State's ready, Judge.
All right, very good.
Bear with me, let me put it up now. The court has just gone live. So let me put it up here. And then we'll get on with it. Please like the stream as well, please. I know some people are here. Please make sure you like the stream. It really does help me out. Thank you.
We are here for a motion hearing. Mr. Yellowman-Chile, this is something you wanted to bring up this morning at 8:30. You want to go ahead and preface it for the court while we're here?
Yes, Judge. We are seeking to introduce the testimony of Mr. Larry Peterson as an expert in human and animal hair analysis, really human hair analysis. And I believe that the defense has filed a challenge pursuant to 24-7-702, or referred to as a Daubert challenge, to Mr. Peterson's ability to present that expert testimony to the jury.
All right, very good, sir. Anything before we get started, Mr. Cruz?
No, Your Honor.
All right, thank you. Mr. Yellowman-Chile, you may proceed.
Mr. Peterson, if you would please raise your right hand, sir. Do you swear a firm testimony you will give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If you would, please state and spell your name for the record.
Larry Peterson, LarryKeithPeterson.
And, sir, will you just pull that microphone towards you a little bit? Thank you. And are you working full-time anymore?
I'm retired. I retired from the GBI laboratory in 2008.
Okay. And I want to go back to your time at the GBI lab. What roles did you serve in while you were at the GBI lab?
Well, I was a microanalyst. That is a person who evaluates different types of trace evidence. So I evaluated hairs and fibers, glass, paint, tape, a lot of other miscellaneous trace materials. So after my training there, I spent about the last 9 years of my employment there as the trace evidence technical leader in charge of supervising proficiency testing and protocols and procedures.
What is proficiency testing?
It's a test that a scientist would take to determine if they're following proper procedures and have the ability to elucidate the correct answer on scientific analysis.
All right, and I want to back up a little bit from there and go back to your educational background. Did you complete an undergraduate degree anywhere?
Yes, I have a Bachelor of Science in Forensic Science from the University of Central Florida in 1977.
Yes, sir. And after graduating from Central Florida and before you started working for the GBI Crime Lab, did you work in forensic sciences anywhere else?
I have not.
Okay. Did you, subsequent to working at the GBI Crime Lab, did you work in forensic sciences anywhere else?
Yes, in 2008, after my retirement, gained employment with the U.S. Army Criminal Investigation Laboratory, where I spent another 9 years evaluating and testing trace evidence.
Okay. Do you have any professional affiliations, or did you previously have professional affiliations before your retirement?
Yes, I was a emeritus and retired diplomat of the American Board of Criminalistics. I was retired, or am retired status as from the American Academy of Forensic Scientists. I was also a retired member of the American Society of Trace Evidence Examiners and the Southern Association of Forensic Scientists.
Did you ever serve as president of the Southern Association of Forensic Sciences?
I did serve a 2-year sentence, yes.
Have you ever had any studies or articles that have been published?
I have published several articles, I did.
Okay. Have you ever had the opportunity to speak at meetings or conferences related to forensic sciences?
Yes, I have often presented materials and training materials at meetings and conferences between investigators and other scientists.
Okay. And approximately how many times have you spoken at those types of conferences on the issues of forensic sciences?
I don't have an exact number, but dozens of times.
Okay. Have you ever been qualified as an expert?
Yes, I've testified in state and federal and military courts over 400 times.
Okay. And in what areas have you been qualified as an expert?
Areas including mostly hairs and textile fibers and textile materials, glass and wood, chemical unknowns, tape. Probably have lost track of a couple.
Sure. And Your Honor, at this time, I would move to tender Mr. Peterson as an expert in the area of human hair analysis and textile and fiber analysis.
Human hair analysis and textile and fiber analysis?
Yes, Judge.
Mr. Cruz, any objection?
Not to the expert's qualifications, Your Honor.
All right. This witness is deemed an expert in the area of human hair analysis and textile and fiber analysis. You may proceed.
Thank you, Your Honor. As it relates specifically to the field of hair analysis, I want to break down the next portion of our examination into kind of two different categories. One, the science, two, the procedure. So as it relates to hair analysis, do human hairs have unique characteristics?
Human hairs possess a lot of different variable characteristics. The ability to distinguish microscopically one person's hair from another is the basis for having a meaningful association or an elimination from a sample. So it's based on the fact that from a structural standpoint, hairs possess cuticles and the protein, the cortex, the middle part of the hair, medullary structures, all of which from a microscopic level are highly variable, but they are not variable to the extent of a absolute personal identification.
Okay.
It could be the possibility that two persons' hair could possess the same characteristics, but is highly variable within the population.
When you say medullary structures, do you mind explaining what a medullary structure is?
Sure. Inside the middle part of the hair, some people have open tubular air-filled gaps inside the middle of the hair. It's not clearly understood why that happens, but it could just be a space-saving biological feature that happens. But, and not all people have a medullary structure in their hair. Some people have a lot, some people have a variable amount of a little to a moderate amount, but it adds another important characteristic that's either it's there or not there. It can help distinguish one person from another person's hair.
Okay. And when you say variable characteristics, we've talked about medullary structures. What are some of the other variable characteristics that can be used to determine if a hair is consistent with a known sample or inconsistent with a known sample?
So there are other structures that are observable microscopically. For example, obviously pigment. You have different colorations of pigment and different sizes of pigment. What is the distribution of the pigment within the hair? Is it more towards the outer part, the inner part? Is it clumped? Is it separated particles? There are structures called corticofusci, small little air-filled gaps that can appear in a hair. There's also a material called ovoid bodies, some kind of pigment-related clumps of pigment that can appear in hair. The extent and nature of them and the presence or absence are just other variabilities that help add characteristics that differentiate one person's hair from another.
And as it relates to those variable characteristics, are there some that are more common and some that are less common?
Yes, yes. So it is possible that some characteristics may be more highly distinctive than others. As an example, Caucasian hairs, very fine blonde hairs, would generally not have as many variabilities as a thicker, darkly pigmented hair would have, in general.
And so, I guess, as far as the process that you go through when you are going to conduct an analysis, I want to go to the procedure portion of hair analysis at this point. When you receive a submission from a law enforcement agency or however it gets to you, how is it that a hair analyst begins the process of analyzing a hair sample against a known sample?
So in the laboratory, we'd either receive a collected hair sample that's already in some type of container identified as collected from a particular location, or it may be a recovery where samples of hair are recovered within the laboratory and then isolated. The hairs are first mounted on a glass microscope, slide in a mounting media called per-mount that enables the hair to be observed microscopically. They are looked at under a low-power stereo microscope. Basically, it's a microscope that allows you to see things in more three-dimensional, as you would like normally have a vision and see objects, except these are at like around 10 to 40 times magnified. And you can look at the general characteristics of the hair, its length and thickness. So you can start categorizing a hair to potential racial origin, body origin, and just the observation of general features. And that way you can either easily include or exclude a hair for further testing. So hairs are often excluded as being dissimilar at that level. If they are not, they show similar characteristics at that level. They are then transferred to a comparison microscope. So a comparison microscope uses transmitted light to shine light through the hairs on a side-by-side basis. So there's actually two microscopes side by side. Optic bridge allows you to view both of the samples side by side. And now you're looking at the internal features, the pigment and the medullary structures if they're present. All of the internal microscopic features are compared from the root, or what we call the proximal end of the hair, side by side all the way to the distal or to the far end of the hair samples. Now, if those characteristics correspond along that way, that enables a conclusion that there is an association, that these hairs are consistent, and they could have originated from that person or another person possessing hair with the identical characteristics.
Okay. And as it relates to, and this is going to be particular to the GBI's processes after an examiner makes a determination that their analysis might have some probative evidence, is there any kind of peer review or confirmation process?
Yes. Any probative associations are reviewed by another qualified examiner, and then there's also a file review that would be done for a review of the notes and the report to see if they, reflect correct procedures were followed and the right significance of note-taking that supports that was also present.
Okay. And to your knowledge, the process that you described, is that the process that is generally accepted and recommended in the scientific community as it relates to hair analysis?
Yes, it is.
When you were working in part as a hair analyst for the GBI, is that the process that you applied when you would conduct hair analysis?
Yes.
Are you familiar with the case of involving a murder that occurred in Athens in January 19th of 2001 with the victim being Miss Tara Baker?
Yes.
All right. And did you have anything that you worked on in that case?
Yeah, yes, I produced several reports of evaluations I did on that case.
Is it related to the hair analysis that you did in that case? Did you follow the procedures that you've just outlined for the court in conducting that analysis?
Yes.
Okay. I'm going to hand you, after I show it to defense counsel, what I have marked as State's Exhibit 136. I'm actually going to go ahead and hand defense counsel 136 through 140.
Oh. Good spot, leader. I didn't notice that. Good morning, Bex.
One by one after that.
Yes.
All right, and so, sir, starting with State's Exhibit 136, what is State's 136?
Stage 136 is a scientific report which I generated for this case. It follows case number 2001-1002454, which is the crime laboratory case number for the Tara Baker case.
And does this appear to be a true and accurate copy of the report that you generated?
Yes.
And what was the date of the report?
Report is dated February 2nd of 2001.
Judge, I moved to tender 136.
Any objection? It is admitted.
State's Exhibit 137, what is that?
This is an official report that I generated on February 27th, 2001, regarding some hair examinations, again, under the case number laboratory 2001-1002454.
Does it appear to be a fair and accurate copy of that report that you generated?
Yes.
Judge, I move to tender 137.
Any objection? No objection. It is admitted.
State's 138, what is that?
An official report I generated on March 19th, 2001, again, under the case number 2001-1002454, generated, under the Tara Baker case number.
Does that appear to be a fair and accurate copy of the report that you generated in that case?
Yes, it is.
Okay. Judge, I move to tender 138.
Any objection? It is admitted.
Will you give me the date of that report again?
See, March 19th of 2001.
Thank you, Mr. Peterson. As it relates to State's Exhibit 139, can you tell me what that is?
An official report, which I generated in May 16th of 2001 on the Tara Baker case, again, case 2001-1002454.
And does that appear to be a true and accurate copy of the report that you generated?
It is.
Judge, I move to tender 139.
Any objection? No objection. It is admitted.
140, what are we looking at there?
140, against an official report, which I generated, and this has been October 11th of 2001, under case number 2001-1002454, again, case generated under the Tara Baker examination.
And does that appear to be a true and accurate copy of your report?
It is.
Move to tender 140, Your Honor.
Any objection? It is admitted.
I'm going to hand you several boxes of slides at this point, and they've all previously been admitted into evidence. So I'm handing you State's Exhibits 114 through 122. Defense 31, as well as, I'm sorry, it's State's Exhibits 114 through 125, as well as Defense 31. And I'm just going to hand them to you all in this box right here. I'm going to give you a few minutes. Obviously, that's a number of exhibits to look through all of those. And you just let me know when you're done with that.
Okay.
Do you recognize those exhibits that I just handed to you?
Yes, these are boxes containing prepared microscope slides with mounted hair samples on them, all generated under the case number for the Tara Baker case 1002454.
And so do those exhibits contain some of the hairs that you analyzed in relation to this case?
Yes, these will be the work product examinations of the hair.
Okay. And, you indicated that they were broken, some of them at least. Were they broken when you were analyzing them?
I'm not sure in the circumstance why any of the slides would have been broken, but, I mean, they are glass slides, so it is possible. And if a slide were to break, it would be remounted. The hair would be removed and remounted.
And I probably asked that question poorly, and I apologize for that. While you were conducting your analysis, was the slide broken while you were trying to analyze? Like, as in while you were looking at it, was the slide broken or not broken?
No, it would have been unbroken.
Okay. And so I want to start with your report in States Exhibit 136. If you could, please explain on February 2nd of 2001, what items were you asked to analyze and what were your findings?
Well, there is a listing for item 2. That is, these are items listed under specifically the case number with a description of the sexual assault collection kit taken from Tara Baker. There were question hairs recovered from the buttocks of the victim, the torso of the victim, the left hand of the victim, and there were also known head hair samples submitted from a Chris Melton, Christopher Hall, Jeff Hall, Ashley Peavy, and Valerie Lang.
Okay. And did you, when you analyzed those hairs, what were your findings as far as any consistencies or inconsistencies, as well as any hairs that may not have been suitable for comparison?
Right, so the examination of the pubic combings of the victim revealed that the hairs present were consistent microscopically with the victim's own hair. The hair from the buttocks, there was one head hair consistent with the victim's own hair. There were 2 hairs inconsistent with the known hair of the victim and several hairs that were unsuitable for comparison. And then additional examination of 2 hairs were associated with the known hair of Ashley Peavy that they revealed corresponding microscopic characteristics. At a later date, then there were 2 hairs, too small for microscopic examination, that were later pieced together that could be compared and they were compared at a later report. Hair recovered from the torso. There were numerous head hairs consistent with the victim's own hair. There was 1 hair inconsistent with the victim's hair, which was further associated with the known hair of Valerie Lang.
Then I'm going to stop you right there. So the first set of results we talked about, that's item 8. Is that correct?
That's correct.
And where was item 8 recovered from?
Item 8 was hairs recovered from the victim's buttocks.
Okay. The second set of results that we talked about, item 9, where was item 9 recovered from?
Item 9 was identified as a question hair from the victim's torso.
Okay. As it relates to item 10, which is the next item that I believe we're going to talk about your analysis on, what is item 10?
Item 10 is question hairs identified as from the victim's left hand.
Did you say the victim's left hand?
Correct.
Okay. Were you able to compare item 10 against the known samples that had been provided to you?
Yes. So the results were that there were several head hairs and 1 pubic hair consistent with the victim's own hair.
And so you said consistent with the victim's own hair as far as the hairs in the left hand. Is that correct?
That's correct.
Did you have an opportunity to also compare item 10, the hairs in the victim's left hand, against the hairs I'm going to start that question over again. Were you also able to compare the hairs in item 10, the hairs that were retrieved from the victim's left hand, to the known head hairs of Chris Melton?
Yes. So once the hairs are associated with the victim, they would have already been demonstrated that the other known hair samples submitted would have dissimilar characteristics.
And so, as it relates specifically to Mr. Melton, what would that finding mean as it relates to item 10?
Well, they could not have originated from him.
Okay. State's Exhibit 137 has already been admitted into evidence. What is the date on that report again?
That would be February 27th of 2001.
Okay. And on that report, did you have occasion to analyze hairs that were recovered from a power transformer?
Yes.
And is that item 12?
Item 12, that's correct.
Okay. What was the result of your analysis on the hairs recovered from the power transformer?
The results are that there were 2 hairs unsuitable for comparison and 1 head hair suitable for comparison. And further examination of the head hair found that it was similar or could have originated from Chris Melton.
Okay. And Mr. Peterson, I don't believe at this time I intend to necessarily introduce any of the fiber or textile evidence, so we'll skip over States 138. As it relates to States 139, what was the date of that report?
That report is dated May 16th of 2001.
Okay. And what were you asked to do in that testing and analysis that you did? Well, actually, I'm sorry, Judge. I misread this report. I don't think that that's going to be information that's going to be admissible based on the court's previous rulings. I'm sorry. That's on me.
Is that something that's already been admitted?
It has been admitted, Your Honor, as far as the report for purposes of the Daubert hearing, but I don't believe that it would be admissible in front of the trial jury.
All right, thank you.
And, Your Honor, I don't believe that the state would be seeking to introduce the evidence that was analyzed in State's Exhibit 1. I think it is something that could be admissible, and the witness has already testified to the fact that he used the same methodology in that analysis, but it does not have any analysis of Mr. Melton's hair associated with it. It was other individuals who were collected as elimination samples and some hairs out of a drain assembly. So I'm not going to ask Mr. Peterson about States 140 at this time.
All right.
Judge, I don't have any other questions for Mr. Peterson at this time.
All right, Mr. Cruz, cross-examination. Counsel, let me, can I see y'all at the bench for just a minute before Mr. Cruz gets started?
Hello, Christine.
Let me get your preference.
I mean, there's no point really this guy crossing him because it's like, yeah, we'll let him in. I didn't listen at all because she's going to let it in and I'll hear his testimony when he testifies. That's the way I look at it. I'm in the middle of making a coffee, a Dunkin's coffee as well. Like Americano, but we'll have milk as well. So, yes, that's what I'm doing in between, waiting for that to boil. Let's
Just a
get back
moment,
to
no
it.
testimony is going to be taken. Deputy, good morning. Would you please have the jury come in and we'll have them go into the jury room and then we can give them their menus. They can look over that, but we're going to do that for right now. Thank you, because they're here.
So what, do the jury have to walk through this room or something? Why are they lifting that up there? Ooh, that sounds good. What, the jury coming in, Bex? Or my sexy voice? I'm sexy and I know it. Boop, 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 boop. Right, what are we up to, people? Please make sure that you have liked the stream, please. Most of you haven't, so please take a second to like the stream. That would be much
Good morning, ladies and
appreciated.
gentlemen. We're going to give you the menus for today and let you look those over. We'll be with you shortly. Thank you.
And hello, Christine. How are you, my darling? Terrible roof out. Oh, Sarah P's decided to turn up. Lazy P is coming up. Oh, here she is. How are you doing, Sarah? The coffee, Dylan, the coffee. It's my voice. I know it is. My man boobs. I know. Hello, Sarah P. Well, if you can post the link.
And Mr. Terrell,
I'll
do they
pin
have the
it.
menus for today? Do you have those? Do you have the menus for today for them to look over, or they have them? Okay, very excellent. Okay, very good. Thank you very much. All right, we
I don't know what trial, Christine. The state haven't rested. It's just a door but hearing. And then we'll get into the trial again.
are back on the record. Mr.
Thank you, Sarah.
Cruz, you have the floor.
Mr. Peterson, good morning. How are you?
Good morning.
My name is Attorney Amaya Cruz. I have the privilege and honor of representing Mr. Faust. Is it okay if I ask you a couple of questions? Okay. Were you aware, or are you aware, of the United States Department of Justice, the FBI, the Innocence Project, and the National Association of Criminal Defense Lawyers report regarding microscopic hair analysis?
Yes.
Okay. And in that report, you would agree out of 268 microscopic hair analysis testimonies given, 96% of those testimonies were deemed to be erroneous. Is that correct?
I'm aware that the report states that. You know, the other parts of the report is that it's based only on testimony, and a subsequent report to that pointed out that there is no fault indicated in any of the testing, any of the procedural aspects of the comparison of hair, only that there were reports that reflected testimony that seemed to indicate that hair had a absolute or more
Belong to a particular person.
a particular person, as opposed to it, you know, could be other person's hair with the same characteristics. So they felt that during their review that there were strongly worded testimonies that perhaps would have given a false indication of the strength of the hair.
Okay. And would you agree that the determination is that the proper testimony for a microscopic hair analysis would include inclusion, exclusion, or indeterminate?
Yeah, I would say that sounds reasonable.
Okay, that is fair. But the state, from my understanding, is asking you, and correct me if I say anything wrong, to make a personal identification of who certain hair belongs to. Is that right? Is that how you understand your testimony today?
No, the testimony is that the hairs are associated microscopically. So it states that in an inclusion, the hair either originated from that person or another person who possesses hair with the same characteristics.
Okay. And will that be the limits of your testimony here today?
Yes.
That's my question, Your Honor.
Anything else, Mr. Yalman-Chile?
No, Judge.
All right. Anything from the defense?
This argument.
All right. Mr. Yalman-Chile, you have the opening and closing.
Your Honor, I just reserve.
All right. Mr. Cruz? Well, we've had one. Yes. I don't know where it is. Thank you, Mr. Terrell.
You know, I think the case law across the country is pretty clear when it comes to microscopic hair analysis, especially regarding the Department of Justice's report regarding the personal identification of the hair. From what I understand, the testimony from Mr. Peterson is going to be is that, correct me if I say anything wrong, that the hair is still going to be identified as belonging to a particular individual, but just add the caption on the end, or individuals with similar characteristics of hair. Georgia has not addressed this issue specifically, but Georgia has cited cases that have addressed this issue specifically, particularly Crawford v. State, Supreme Court case of Georgia. The site is 278, Georgia 95, and I'm reading from footnote 10. And the site, and it's very important, the site is the most important thing, is CEG, and as the Honorable Court knows, it supports this proposition and example given. Scott v. State is one of the sites. It is 581 SO period 2D 887, and this is page 892 that Crawford is citing. This is a 1991 case that Crawford is citing. Crawford is 2004 to give the Honorable Court the date of that case. But it states, it is important to recognize that hair comparisons do not constitute a basis for positive personal identification. So our argument is to the Honorable Court, the science, we have no issue with the science. It's the conclusions that we have the issue with. The science is solid when it comes to, we have this hair, these are the characteristics of the hair, but as far as saying, hey, this is Mr. John Doe's hair, this is not Mr. John Doe's hair, the science isn't supported in that way. Crawford also states State v. Faircloth, and that's FAIRCLOTH, and that's 99, capital N period, capital C period, APP period, 685. And again, Crawford is a 2004 case, but it's citing a 1990 case from North Carolina. And it states, this is the cite from the North Carolina case. Unlike fingerprints, however, comparative microscopy of hair is not accepted as reliable evidence to positively identify a person. The case also cites State v. Butler, 24 Southwest 3rd, 21. And just to give the Honorable Court the proper information on this case, this case is still good law. It's citing a case from Missouri, still good law, but it was a separate portion of the case was overruled, okay? But this portion is still good law, at least at the time of this case. And what it states is, as the expert acknowledged in her testimony, and as the authoritative articles confirm, there is no scientific basis for testifying that a hair comes from a particular person. Your Honor, I think you've seen this yourself. I think it speaks volumes that the state did not attempt to introduce any articles. We had a Daubert hearing last night with Mr. Chris Bolden, and he at least made sure that he introduced some literature to support the proposition that what Ms. Lycombe was doing was somehow, some way supported by the science. Here, the reason no articles were supported, and of course the state has the burden, is because the articles that are out there, the error rate is as high is 96%, and that was the FBI report that I discussed with the Mr. Thank you, Mr. Peterson. With Mr. Peterson, but also as high as 67%, but on average, as high as 96%, but on average a 67% error rate. So the science, as Mr. Peterson said, is good science. However, you can't take that science and make a conclusion. What it requires is mitochondrial DNA testing that follows up to confirm or exclude. The limitation that I'm asking for Mr. Peterson's testimony, because I'm not saying the science is junk science, I'm just asking that he's not allowed to testify that, hey, this hair belongs to Chris Melton, this hair belongs to Ashley Peavy, this hair belongs to John Doe, or whoever it may be, because the science doesn't support that, the literature doesn't support that, and the state has the burden. And the state hasn't presented anything to support, to show that this process is peer-reviewed. They haven't brought in any evidence about the error rate. The only thing they focused on were the conclusions. And the conclusions in this case, and with microscopic hair analysis, the conclusions that positively identify a person is what's inadmissible, Your Honor. And that is our position. So we would just simply ask the Honorable Court to limit the testimony. We're on the same page as far as the science. The only issue in this Dauber hearing is the conclusions that could be made. We would ask that the conclusion is simply limited to, if you want to describe the characteristics of hair, and say exclusion, exclusion, or indeterminate. We have no issue with that.
Okay, Mr. Cruz, let me make sure I know what you're asking the court to do. So what it sounds like that you are not contesting the state's presentation of the requirements of 702. Is that right?
No. So in my argument, I'm saying that I don't contest the science, but the state still hasn't met their burden. So I want to make it clear. I'm not saying I agree to admission of this testimony. I'm just saying, as far as argument, I'm not arguing that the science is junk science.
Okay.
But the state hasn't met their burden to admit this argument, so I do want to make that clear.
Okay. All right. Well, that was my question.
Okay.
All right. So the second portion of your argument, though, is inconsistent with the hearing we're having right now. So I guess what I need to understand from you, just so I know what you're talking about, is that you are still contesting this expert's ability to testify in court.
Correct.
And are you also saying that if this witness is allowed to testify, that you want his testimony to be limited?
Correct.
Okay, so you're sort of asking for a motion in limine to some extent. Is that what you're asking for?
If that's the way
Okay.
it comes across, that's fine with me.
Okay, so you're really asking for two different things. You're asking the court to grant your motion with regard to 702. Is that right?
Correct.
Okay. But you're also asking that if the court does not grant your motion, you're asking the court to limit, in a motion in limine, this expert's testimony.
And just to make it clear,
Not say a conclusion as you have articulated.
correct. And we may be saying the same thing, Your Honor, but I understand it as that is a part of 702. It's the testimony that the state is seeking to admit. So I'm saying, my understanding is I'm arguing under 702, the state hasn't met its burden to show the science is good science.
I understand.
But also, if the Honorable Court says, I disagree, we're asking the Honorable Court to limit the testimony because the state hasn't shown in any manner that the particular testimony that they're seeking to elicit from Dr. Peterson is admissible under 702.
Okay, and that's what I'm calling a motion in limine. But I understand what you're arguing now.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
All right, Mr. Yellman-Chili, any closing?
Yes, Judge. As it relates to the science, am I understanding Mr. Cruz's argument to be that he is not challenging the validity of the science of hair analysis, correct?
I want to make it clear for the record. In closing for our conversation, I'm just advising the Honorable Court that I am not saying it's junk science, but I want to make this clear. I'm not consenting to this testimony. The The entire scope of this hearing is for the state to meet its burden. So that's what I wanted the Honorable Court's ruling to focus on, whether or not the state met its burden to if the sign should be admitted in this court.
And I'm just asking so that I understand what I need to argue, because obviously if the body of science itself isn't being contested, then I can limit my argument to what I think the testimony was from Mr. Peterson regarding what his opinion would be.
The body of science is being contested to the extent that the state has to meet its burden of proof under 702.
Okay, all right. So, right, all right. I think I understand now. Your Honor, I'm going to hand Mr. Cruz as well as the court a couple of cases, and hopefully I'm not handing anybody my highlighted copy. And Your Honor, can I approach?
You may.
I handed the court two cases. The first case is United States v. Brown. That is 415 F3D 1257. And then the next case is U.S. v. Barnes, which is 481 Federal Appendix 505. Brown is a 2005 11th Circuit case, and Barnes is a 2012 11th Circuit case. And they both stand in general terms for the fact that the court has broad discretion in its ability to review expert opinion evidence and determine whether or not it is admissible under 702, and in particular as it relates to Barnes, which is the 2012 11th Circuit case. If we go to the fourth page on the right side of that opinion, Your Honor, in section E, you will see a discussion of hair and fiber expert testimony that was elicited and admitted in that case. And then if you go forward to page 6 on the bottom of the right side, going into the top of page 7, the case discusses the Daubert factors and makes clear that that is not a those are things for the trial court to consider in its determination, but they're not factors that must all be met in order to allow the admissibility of evidence. The court is still able to exercise its discretion in determining whether or not evidence should be admitted, and that's certainly the case in situations where expert testimony is supported by science and is going to be helpful to the trier of fact in determining an issue, but the scientific field and the methodology used don't allow for quantification, but they are methodologies that are generally accepted within the scientific field. So I think that that touches specifically in Barnes quite explicitly on hair analysis. Again, that's a 2012 11th Circuit case. Obviously, as the court knows, the 11th Circuit is the circuit we look to when we're looking for rulings that can be helpful to Georgia courts when applying standards that have longer been standards in the federal system than they have in the Georgia system, whether that be the rules of evidence or whether it be shifting to the Daubert standard in 24/7/702 for the court's analysis of when to admit expert testimony. And so I think given those factors, as well as Mr. Peterson's testimony about the methodology used being scientifically accepted and his having applied it in his analysis in this particular case, I do believe that the state has met its burden.
That's actually a test Clark County is doing this morning, just so everybody knows. We're not under attack, I don't think. I certainly hope not, but that's my understanding. It was 9:30, and I realized that's what it was. So I got an email about it yesterday, and I didn't think about it.
Would you like me to just wait till it's done or just keep going? I'm fine either way.
Let's just wait for a moment because it's just going in and out. So.
I mean, she's going to accept it and she's going to let them testify, but she should limit it like the defense are asking. Will she? I won't lie to you. I was pissed last night after she let that perceived expert in to testify. That was like the final nail for me. I was like, I feel so sorry for this defendant. He's got such an uphill battle against this court. And I've always said, I don't, whatever happens, but every defendant deserves a fair trial. And that's why some people get angry at me if I say, because we all like different attorneys, we all like different styles, we always cheer on people that we like, but it shouldn't be the case. We should always have that level playing field. Judges are always going to rule for and against you.
Good to know our system works.
But this judge,
emergency management
shut
notification
the fuck
system.
up, Judge. This judge rules against defense every time except for once. And the one time she didn't was because it was a jailhouse photo. A jail, wherever, you get that profile of you when you get arrested. And she knew it was against the law to put that in. She had to take a 15-minute break for it. So, it sucks. It sucks. Thank you, Badaza, for liking my tweets. Badaza's a real one. Badaza's also a fucking pain in the ass, but we all love him. Hello, talk about pain in the asses. Hippie chick, hope you're feeling better, Medallion. Nice to see you, Spacey Stacy, as well. I hope you're all doing well. I agree, every trial should be fair. But what I'm saying is, we're always cheering on the ones that we like, If this was a defense, we'd be cheering them on. But it just goes to show we need to be even-keeled with it all. This trial should show you how lopsided
I think you're good.
It is.
Thank you, Judge.
Go ahead.
As it relates to the method and, I guess, the form of the opinion that Mr. Peterson would offer, I disagree with defense counsel's characterization of the response that Mr. Peterson offered. I think, in fact, the opinion that Mr. Peterson offered, as well as his response on cross-examination, is that he is not offering an opinion that an individual whose hair is deemed to be, and I'm going to look at the actual language from the opinion, consistent with the known head hair of a sample. It is not to say that that is exclusionary of every other person possible, similar to the way DNA evidence would be exclusionary to, a certain degree of mathematical certainty. In fact, he said the opposite of that, is that his opinion would be that it would be consistent with that individual or another individual who had those same characteristics in their hair. So I think that is certainly the type of opinion that does not run afoul of some of the propositions that Mr. Cruz has stated to the court, in that his opinion as it relates to hairs that either consistent with the known hair of someone or someone else who has those same characteristics. Now, he said that if there is some opinions in his report that I'm interpreting his response as saying, this individual can be excluded as a source of this hair because the characteristics are inconsistent, and so we know we can exclude that person. And I think he mentioned some hairs that were not suitable for comparison. I don't know that we elicited any opinions about, not being able to form either an inclusive or exclusionary opinion. But certainly there was no testimony, and in fact, testimony to the opposite of the idea that hair analysis could yield quote unquote match that would be of the type that we would think of when we were thinking about DNA analysis. So I don't think that's the opinion that Mr. Peterson's indicated that he is going to offer. And I believe the opinion that he indicated he's going to offer is an opinion that Mr. Cruz in his argument said would be a valid opinion to offer in the field of hair analysis. So I'd ask the court to allow him to testify consistent with what he has represented his testimony would be in front of the jury. Thank you, Judge.
Thank you. All right, with regard to this particular witness, I've already deemed him an expert in the area of human hair analysis and textile and fiber analysis. I'm making a finding under the requirements for 24-7-702 that the state has, in fact, met its burden. With regard to number one, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. I think it is clear from the testimony and how Mr. Peterson explained what he analyzes that that testimony is not that which a layperson would know. With regard to number two, the testimony is based upon sufficient facts or data. The testimony was that this expert's analysis was, conducted, sorry, I'm confusing my notes here. That his analysis is based upon sufficient facts or data. With regard to number four, this...
I imagine the notes that she created yesterday before even hearing any arguments. She's a habit of doing that. This bitch, I'm telling you.
Expert has testified that he has reliably applied the principles and methods to the facts of this case. He has testified about the process. He has testified about the manner in which his analysis is reviewed, how that is consistent with his tenure at the GBI, that it is accepted in the scientific community, that his methodology is scientific, and that he also used the processes that he described in analyzing the evidence in this particular case. And so I believe, based on the evidence that the state has presented through Mr. Peterson, that they have met their burden under Daubert. With regard to the motion in limine, the reason that I'm going to deny your motion, Mr. Cruz, is because it is not necessary. It is clear that this expert is not going to testify in the manner that you're asking for him not to. That his testimony is one of either consistency or elimination, but his testimony has not indicated that he is commenting on his analysis in the way that you were asking the court to exclude it. And so I'm just making a recognition of that. I don't think it is necessary. Should it become necessary, I'll have a hearing outside the presence of the jury and we'll discuss it. But that certainly has not been the case in the hearing this morning. So I'm going to deny your motion with regard to 702 and this particular witness. All right. Is there anything we need to take up? We're going to take a quick break and then bring the jury out. Ask the state first. Anything we need to talk about before we get started?
No, Judge.
All right. Mr. Cruz, anything, sir?
No, Your Honor.
All right. Very good. We are going to take a 5-minute recess and then we'll bring the jury in. Thank you.
Do you think that the state should just put a motion together and just be like, hey, Judge, we're a motion together. Can you just, you like to go against the law and stuff like that. Can you just make a decision? Can you just send him to jail, to prison? Can you just send him to prison for life without parole, please? So let's skip the jury part. And she'll probably go, well, there's no law saying I can't do it. She'll find something. There's no case studies. Maybe I should. Yeah. Do you know what, state? Yeah, that's a great argument. But it's unconstitutional, Your Honour. Well, it doesn't really matter, does it, he's going to prison anyway, so who cares, you know? I'm making sure that he's going to prison. So, I mean, it has to be the worst trial I've ever seen in case of a defendant. There's a few we've seen, obviously, but nothing compared to this in the sense of how biased and how this guy is having such an unfair trial. You know, I just don't get how junk science in a lot of ways can go in and they can testify to it. Yesterday, we heard that there was evidence that has been moved and been lost and maybe been contaminated, but it doesn't matter. They can still testify to it. It's all good. What are we doing? I don't get it. I honestly don't get it. I really don't get it. Right, just go ahead and sentence him for real. He's screwed in her eyes. I hope the jury doesn't find him guilty. I think they probably, would lean that way. I just hope that when it comes to closings, they're able to distinguish, like, potential. We don't know what's coming in. They might still be able to show how he did kill her. I don't think they will, because they've lost a lot of evidence, and they've lost the window, whatever you call it, the window, I forget, the box around the window. That was key evidence, which, hang on, it's now missing. It's now disappeared. The casings around some of the key evidence is broken. Oh, no. But no one knows how or when, or was it contaminated? No one knows. 3 pieces of the hairs that were on the body, gone. £200 in America is about $300. Dave, about $300. It's about 66 pence to the dollar. 67, sometimes 70, but I just hope that no one ever has to go through something like this, because literally this could be anybody. This guy could be walking down the street. This guy could have been literally meeting up with Spacey Stacey, Chicken Lady Di, and has now been arrested. And I'm not forgiving the fact that, they're saying that his DNA is on the bodies. I'm not, that's fine. But first of all, prove it. First of all, prove that there's no contamination, because we do know that there's potential contamination. We do know you've lost stuff. I have no confidence in any of this. The alibi of Chris is based off his parents and one of his best friends. So his alibi is, trust me, bro. Trust me. So, and I think it's just as plausible that he could have slept with the woman, with the victim. Sorry, I don't want to call her a woman, a victim. Who bloody knows? And also, they said at the beginning that when they interviewed him or spoke to him, they asked him if he knew of Tara. Do you know of a Tara? And he said, no, don't think so. Have you ever slept with Tara? No, not I'm aware of. I will ask you, ladies, think about all the men that you've slept with across the years, all the one-night stands you've had, and I'm sure most of you have had plenty of one-night stands. Like, how many do you truly remember out of state? Unless you obviously know them, but I'm sure many of you have just slept with randoms. Do you remember what their names were, what they looked like, what their dates of birth were, what their name was fully? Some of you might be able to. Some of you are like, yeah, I didn't open my legs all that often, but I know some of you will probably open your legs quite often. So, it's impossible to remember everybody, in my opinion. But maybe it's just a man thing. I don't know, Dave. I don't know off the top of my head. And then they say, great alibi. That guy walking did it. I know. I don't know. It makes me sad. No, I do mean out of state. Whether it's in state, out of state is what I meant, Katie. Not like if it's in or out, Confession, I've only been with my LH. No, that's late husband. That's absolutely fine. I mean, sorry, Angela, I'm being crude. I'm half joking in that sense. That's my dark humor. For people that don't know me, I have a dark sense of humor, and that's why I say that, because I know like hippie chicks in here and stuff, So, would never have a one night stand. That's fine. I mean, again, I'm obviously teasing everybody here, so Lady Di bullshit. But yeah, after my divorce, a few, yes. Again, I'm not judging anybody, and I am joking when I say that. I'm not, I'm only calling a few of you out. No, actually, it's only Bex, Hippie Chick, and Lady Di. That's all. And a few others. But my point is, how are we supposed to actually know everybody that you've kissed or been intimate with? I don't know. Maybe I'm wrong. I just think this reasonable doubt right there. Out of states, I don't know, Katie. I can tell you now, I don't remember everybody. I'll be honest with you, I have no clue. If you came knocking my door and said the name, I'd be like, maybe, I don't know. So, I shouldn't have started this topic because now Dave and Bad Daz are going to be all over it. So, apologies, advanced ladies, that you have to deal with that. But my point was that, we can't always remember everybody that we've either, kissed or been with. Some people will be able to, but not everybody will. So I'm not going to hold that against him. You have to prove more than that to me. Him walking past doesn't really prove that to me when you've got a Walmart behind the housing estate there. I'm not willing to put someone in prison for the rest of their lives based on what I've heard yet. Also, I'm not willing to put somebody in prison for the rest of their lives based on some shoddy, which I don't even know what the DNA actually reads or anything yet. So, Bex, I was very much a party guy, yes. Right, talking about parties, Aaron Hack, I hope Rocky's having a party, because he's about to get his balls are about to be spanked. Please hit the like, people, as she says. All the ideas, mornings. No worries at all, Andriel. I appreciate that. I'm glad you didn't take offence to it. It was not meant to be offensive, and now I need to put my live chat on. So, the Jordan's rule of evidence, they are not allowed to talk about the victim's story they're not allowed to speak about it because of the RA and stuff like that, and her sexual past and stuff. They can't get into it. Allegedly, Chris is on it and other people.
For disclosure, I just
Oops.
Located a witness that we had previously tried to find. He wasn't included on our witness list because I couldn't find any good information for him. But I bumped into him into the courthouse, and I'm assuming the state they have an objection to it. But we're going to amend our witness list tonight. Provide state notice of his information. I just got his information. Which would allow us to bring him in during our case in chief. But I do think because it's in the middle of trial and it's kind of last minute, it's something that does need to be brought to the attention of the honorable court, just so the honorable court to decide if this is something the honorable court would allow or not allow, and that would determine our preparations.
All right. Thank you, Mr. Yellenman-Chili.
I guess one of the first questions would be, who is it? And as far as a determination for the court, what would this person testify to? I don't know that not having contact information is grounds for not including somebody on a witness list. If it's newly discovered information, that's a separate thing. But before the state takes a position, I just would need some more information as well.
All right. At this point, I'm not going to allow another witness on the witness list. The witness lists have been out for a long time. They have been subject to amendment before we began this trial. If it was somebody that either side knew that they wanted to testify, even if they couldn't find them, that person needed to be included. The jury, the entire jury pool, but particularly the jury that has been seated, they were all asked questions about whether they were related by blood or by marriage to all of the witnesses in this case. And that would not have been done for this particular edition. And so I'm not going to allow it. All right. Anything else before we bring the jury in?
I just would like to get a sense of the court's preference. Our next witness is going to be Ms. Lacan, who testified last night. Right. Certain exhibits were admitted during that Dahlberg hearing last night. It would be the state's preference to just use the same exhibit number just for, and I don't know that.
I mean, I think the same exhibit number is appropriate. Mr. Cruz made it very clear, unless you tell me otherwise, it was admitted for the purpose of that hearing only. So you'll go through the same process if you want to, about admission of evidence, if you want to admit those. But I think the numbers need to stay the same.
That's what I thought too, Your Honor. I just wanted to be clear before I started putting stickers on things.
Okay, very good. Thank you. All right, anything else?
And Judge, this is kind of in that same vein as it's going to relate to Mr. Peterson's testimony. The copies of his reports that I admitted during the Dahlberg hearing are not redacted. And so would the court want me to redact what's already been admitted prior to it being shown to the jury or handed to the witness? Or would you like me to leave it in its actual form as it was admitted during the Dahlberg hearing?
I'm not sure I understand what you're saying. Are there portions of the evidence that you admitted during the hearing that need to be redacted?
Yes, Judge.
Okay.
In accordance with the court's ruling on the state's sodomy motion, some of the information listed as far as suspect or some of the elimination samples that aren't actually relevant to the trial of the case.
Sure. I would say this as a general rule. Mr. Cruz, you certainly can respond before I say anything about what he's referring to. Anything you'd like to add?
No, ma'am.
Okay. Thank you. So I would say, Mr. Yalamanchili, for efficiency purposes, that it would be imperative to redact what is appropriate to redact before you tender it. And I think that's the best way to handle it, as opposed to after.
Yes, Judge.
All right.
Happy to do so.
All right, very good. And you can show, obviously, Mr. Cruz, what you're redacting. If you have any objection to that, obviously we'll take it up before it gets admitted or is offered for admission. But
Thank you, Your Honor.
Thank you. Mr. Cruz, anything before the jury comes in? No, all right, thank you. You may bring the jury in.
Only thing I'll say is, right, she made the right ruling. She shouldn't, the defense should not add just random on the witness list. Like, they should have put the name down. So I agree with her, but she still should have had a hearing about it, just to do it legit. She got the right ruling, in my opinion. It's just frustrating because she always rules against them. So it sounds like she's a bitch, but actually that was probably the right ruling. But she's still a bitch.
Everyone may be seated. Thank you. Good morning, ladies and gentlemen. We are back here in court today with regard to State of Georgia versus Edrick Faust, SU 24 CR 0547. I appreciate you all arriving here on time, as usual. I just want to let you all know that we are starting late today, and I promised you that we would be as efficient as we could, and we are actually keeping to that promise. It may not seem like it because we're starting late. I just want to explain to all of you. We were here late last night handling some matters, of course, that needed to be done outside your presence. The attorneys were here really late. We knew we needed to be here today, to handle some other matters outside your presence. I didn't have it in my heart to make them come in at 8 o'clock because it was a long day yesterday and we were here really late. So we got here at 8:30 and started right away. And obviously we weren't finished until now. So I just want you to know we're not wasting your time and chatting about things that we don't need to be chatting about. I just want you to know we've been working very hard to get through some things so we can get started. I appreciate you all filling out the lunch menus. Of course, we're doing that again today because we have an early day today, and I just want to get through things as much as we can. On Monday, we'll go back to kind of a regular schedule, and we'll have a regular lunch hour. You all can leave and stretch your legs and get some fresh air and things of that nature. And so I just wanted to make sure you're aware of that. All right, we're going to get started. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right, thank you. You may call your next witness.
Marissa Lacan.
Could you get Marissa Lacan, please?
Ma'am, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Can you please state your name and spell it for the court reporter?
Marissa Lacan, and it's spelled Marissa. Last name is Licon.
Ma'am, how are you employed?
I'm employed at Pure Gold Forensics.
How long have you been employed at Pure Gold Forensics?
Since May of 2022, so approximately 3.5 years.
And tell us a little bit about Pure Gold Forensics. What is it?
We're a private accredited forensic DNA testing lab located in Southern California.
What kind of testing does Pure Gold do? Generally speaking.
So we do serology as well as DNA testing for prosecution, defense, as well as private parties.
What is your position at Pure Gold Forensics?
I'm a forensic scientist.
Can you please explain what your job entails?
So it involves serology testing as well as DNA testing using Global Filer as well as Y-Filer amplification kits. I analyze mixtures using StarMix probabilistic genotyping software, interpret the data, and producing a scientific report based on the data.
Can you talk a little bit about your educational background?
I have a bachelor's of science degree in forensic chemistry with a concentration in criminalistics.
And other than the education that you received in obtaining that degree, is there any other training or experience that you have that has assisted you in your work as a forensic scientist?
Yes, so upon being hired at the lab, I underwent their training program. So it was approximately 1.5 years total. I was first trained in serology, which is the identification of body fluids. I underwent an observation period in which I watched another analyst perform the testing, a practical period in which I performed the testing on mock samples. I completed a oral as well as a written exam, and then completed and passed a competency test. I was observed on 3 cases before I was signed off to do independent casework in August of 2022. Subsequently, I was trained in DNA analysis, in which I also underwent an observation period, a practical period, where I performed testing on mock samples using different extraction methods. I completed my own sensitivity as well as mixture studies. I completed and passed 2 competency tests, as well as 2 moot courts, and completed an external 4-day StarMix training. And
ma'am, are you a member of any professional organizations?
Yes, I'm an affiliate member of California Association of Criminalists, as well as a professional affiliate member of American Academy of Forensic Sciences.
And ma'am, outside of this case, prior to coming to Athens, have you ever testified as an expert in court before?
Once.
Okay. And where was that?
In Colorado.
And what was the nature of that testimony?
DNA testing.
Your Honor, at this time the state would ask that Ms. Lacan be permitted to testify as an expert in forensic chemistry and forensic biology.
Any objection from the defense?
Based on honorable court's prior ruling, no, ma'am.
All right. This witness is declared an expert in the areas of forensic chemistry and Forensic Biology. You may proceed.
Thank you, Your Honor. Ma'am, back in 2024, was Pure Gold Forensics asked to perform certain serology testing on 2 items of evidence submitted from the GBI Crime Lab?
Yes.
What items did you receive from the GBI?
We received 2 items which were apparent cuttings of swabs.
How were those items submitted to your lab?
We received them via FedEx.
Okay.
I'm going to hand you an item that's been labeled, I believe, States 141. Is that right?
Correct.
Okay. And what is States 141?
It's the envelope we received.
Okay. And how do you recognize that envelope, ma'am?
This is the envelope I opened and tested the items inside.
Okay. And does your initials appear on that item?
Yes.
In what condition was States 141 when you received it at Pure Gold Forensics? Was it sealed? Let me ask.
Yes, it was sealed.
Okay. I'd move to tender States 141, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Ms. Lacan, inside States 141, are there a number of items in there?
Yes.
Okay. Can you take those out? Okay. States 142, what is that?
This is Georgia Bureau of Investigation, their evidence transfer receipt.
And was that, again, located inside States 141 when you received it at Pure Gold?
Yes.
And in fact, as going back to States 141, was that item completely sealed until just a few minutes ago right outside of court?
Yes.
And did you witness it being opened prior to coming in and testifying?
Yes.
Okay. States 142, what is that?
That's the transfer receipt.
Oh, I'm sorry, 143. Pardon me.
This is an envelope labeled cuttings of item 2I, oral swabbings B.
Okay. And 144, what is that?
A sealed envelope labeled cuttings of item 2J, oral swabbings A.
And just again to clarify, when you received States 141, were 142, 143, and 144 all contained inside of it?
Yes.
Do you recognize, especially as it relates to 143 and 144, those items as having your initials on them?
Yes.
At this time, I'd move to tender States 142, 43, and 44.
Any objection, Mr. Cruz?
No, Your Honor.
They are admitted.
Can I first do this again?
You may.
Ms. Lacan, based on the request, as you might have understood it from the GBI Crime Lab, what, if any, tests did you believe may be relevant in making any determination as to the potential biological source of the items of evidence that were contained in states 143 and 144?
We were requested to perform saliva testing as well as vaginal epithelial cell testing. So I determined that our RSID saliva test as well as our Lugol's iodine tests presumptive for vaginal epithelial cells were appropriate.
Okay. Let's start with the RSID saliva test that you just described. Briefly, ma'am, what is amylase?
It's an enzyme found in saliva.
Okay. And where is amylase primarily found in the human body?
In the mouth, saliva.
How does the RSID saliva test test for the presence of amylase in a biological sample?
So it's a lateral flow test strip. So essentially you have your sample that's been extracted and you combine it with a buffer that comes with the test kit, and then you deposit that onto a cassette that has a membrane that contains antibodies that are specific for the antigen, which in this case is the alpha amylase from saliva. And when you deposit your sample, if the alpha amylase is present, the antibodies will capture it, and it'll continue down the membrane. And a positive test will result in 2 visible lines, and a negative test will result in a singular line.
Does it kind of resemble like a COVID test?
Yes, or like an at-home pregnancy test.
What does RSID stand for?
Rapid stain identification.
Oh, you mentioned that. I just want to be clear. Has the RSID saliva test been validated as an appropriate test for detecting the presence of saliva at Pure Gold Forensics?
Yes, we complete our own internal validation.
And has Pure Gold Forensics tested for the sensitivity of the RSID saliva test?
Yes, so during our validation, we tested different dilutions of saliva, and we came to the conclusion that the RSID saliva test kit can detect as little as 10 nanoliters of saliva, and so there's 1 million nanoliters in 1 milliliter.
So that a significantly small amount of
Yes.
a sample? Okay. Can the RSID saliva test yield false positive results?
There are other biological fluids that can yield false positives, such as human breast milk, fecal matter, and high concentrations of sweat.
And when we say false positive, just to be clear, what exactly does that mean?
Another substance that can give a positive test, but it's not the specific substance you're testing for.
Okay. And based on the possibility of a false positive result, is the RSID saliva test only considered a presumptive test rather than a confirmatory test for the presence of saliva?
Yes.
Okay. And can you just kind of explain for the jury what we mean by presumptive test versus confirmatory test?
So a presumptive test gives the likely presence of a substance, but due to false positives, it's not a definitive yes or no, whereas a confirmatory test is highly specific and can give a definitive yes or no, this substance is present.
Ma'am, to your knowledge, is there a confirmatory test regarding whether or not a sample of biological evidence is positive for the presence of saliva?
No.
And is the RSID saliva test generally accepted in the scientific community as a presumptive test for the presence of saliva?
Yes.
I want to shift gears a little bit and talk about Lugol iodine. What is the Lugol iodine test designed to look for?
It's designed to look for glycogen.
Okay. Before we get into glycogen, let's talk a little bit about epithelial cells. What is an epithelial cell?
It's a skin cell.
Okay. And can epithelial cells come from all over the human body?
Yes.
Can you please describe, generally speaking, the science behind the Lugol iodine test?
Yeah, so the premise behind the test is that the glycogen content of vaginal epithelial cells is extremely high between a woman's first menstruation and menopause. So when these cells are stained with the Lugol's iodine, they'll exhibit a dark chocolate brown color. There are other areas of the body that do contain glycogenated cells, such as oral secretions, as well as the urethral opening of the penis. However, the glycogen content of these areas is less abundant. So based on our validation as well as studies, we use a 10% threshold that if more than 10% of the cells stain the dark chocolate brown color, it's considered a positive indication for vaginal epithelial cells.
And ma'am, I think you might have hinted at this just now, but can you explain a little bit about why the Lugol iodine test might yield different results on a sample collected from a vaginal swab versus a sample collected from an oral swab?
Yeah, so amylase that was mentioned earlier that's present in saliva breaks down glycogen, so that's why there's a less abundant amount of glycogen in oral secretions.
And again, I think you might have answered this a minute ago as well, but is there a generally accepted percentage of chocolate-stained cells that one might observe which would indicate that a sample was collected from a vaginal swab?
Yes, we use a 10%.
And is that percentage higher or lower than others may have accounted for?
Yeah, so there's a study that examined buccal cells versus vaginal epithelial cells, and they determined that with a water extraction and mechanical shaking of the sample, actually less than 1% of oral secretions will stain the chocolate brown color. So our 10% threshold is more conservative.
Is the Lugol iodine test validated by Pure Gold Forensics as a presumptive test for the presence of vaginal epithelial cells?
Yes.
And to your knowledge, is there such thing as a confirmatory test for the presence of vaginal epithelial cells?
No.
Ma'am, when you received what we've tendered into evidence as states 143 and 144, these are the samples of cuttings, is that right?
Yes.
Please describe the process by which you undertook the testing that you performed.
So I first reviewed the case file, and then I removed the evidence from our evidence storage, took it into the evidence examination room, where I opened it, took photos, took notes of it, and then I took it for our extraction procedure. It's our analytical procedure 5, which is a general extraction procedure that allows the analyst to retain the substrate, take the liquid portion for serology testing, and then take the cell pellet portion for either DNA extraction or microscopic examination.
Okay. And once you did all that, did you perform both the RSID saliva test and the Lugol iodine test on each item?
Yes, I did.
Okay. And just to be clear, when we're talking about the Lugol iodine test, how are you looking for or observing those chocolate-stained cells that you just described earlier?
The process of putting them on the slide?
Yes.
So it goes back to the extraction procedure. So I take the substrates, which in this case were the apparent cuttings of swabs, and I place them into a test tube along with sterile water. We allow it to incubate for approximately 30 to 60 minutes, and during that time period, we vortex it several times, which means to shake vigorously. We do that by putting it on a machine. When that time period has passed, we centrifuge, we take the substrate and we put it into a spin basket on top of the same tube, and then we centrifuge the tube extremely fast so it spins fast, which pulls the liquid from the substrate. At the same time, it causes the cells within the sample to pellet at the bottom of the tube. So when that's done, we remove the spin basket, place it into a separate tube, and then left in the tube we have the liquid portion as well as the cell pellet. We pull off the majority of the liquid portion and then place that into a separate tube. That's what we refer to as the supernatant, which can be used for the different serology tests, so body fluid identification. And then left in the original tube, we have the cell pellet along with a small amount of liquid. So to get to the microscopic exam part, we vortex the cell pellet along with the liquid, and then we take a small amount, so 2 to 10 microliters, and we place it onto a slide, heat fix it, and then we stain it with the Lugol's iodine.
Thank you. And again, I want to talk about the testing results, specifically related to States 143, which is your item number 1, labeled as cuttings of item 2I, oral swabbings B. That's super confusing. As it relates to this particular piece of evidence, regarding the RSID saliva test, what was your result?
It was positive for RSID saliva.
Objection. I believe that exceeds the scope of the Honorable Court's ruling in regards to Dauber yesterday, if I'm not mistaken.
Yes.
I believe that testimony that we just received exceeded the scope of the testimony expected from the Dauber hearing.
Mr. Bolden, any response?
I mean, the fact that it's positive, I think the witness has established that that's not a confirmatory test, it's just a presumptive test.
Yeah. If that's in the form of an objection, I'm going to overrule the objection. Go ahead.
If I can approach, Your Honor?
You may.
Ma'am, I'm going to show you what's been marked as States 145. Do you recognize that?
Yes.
What is States 145?
It's the RSID saliva cassette testing results from our item number 1.
Okay. And does that picture fairly and accurately depict the results of the test on the cassette?
Yes.
Contender States 145, Your Honor?
Any objection?
No, ma'am.
It is admitted.
And Ms. Khan, did Pure Gold actually retain the cassette itself?
No, as long as we take a photo of it, we throw it away after.
With regard to the Lugol iodine test on States 143, what were your results on that, ma'am?
It was negative for the presumptive presence of vaginal epithelial cells.
Okay. And did you take a photograph of the microscopic slide that led you to that conclusion?
Yes.
If I can approach again, Your Honor.
You may.
It's going to get really confusing because we're going out of order. This is States 134. You recognize that?
Yes.
What is States 134?
A field of view from the microscope slide from our item number 1.
Is that a fair and accurate depiction of the slide as you observed it when you conducted the Lugol iodine test on that piece of evidence?
Yes.
Move to tender States 134.
Any objection?
No, ma'am.
It is admitted.
Your Honor, if I could publish
All right.
145 and 134 to the jury at this time?
Are you going to do it on the machine?
Yes, ma'am.
It is on.
Thank you. All right, we're going to start with States 145. Ms. Lacan, again, what is this?
This is RSID saliva cassette testing results from our item number 1.
You indicated that that was positive, a positive test?
Yes, it's positive.
And how do we know that?
With the visible 2 lines.
States 134, again, is that the picture of the microscopic slide after performing the Lugol iodine test on States 143?
Yes.
Okay. What are we seeing here?
We're seeing yellow staining, so epithelial cells that are not glycogenated will exhibit a yellow or no staining.
With the Lugol iodine tests, what was the result of that, if I didn't ask?
It was negative for the indication of vaginal epithelial cells.
Thank you. All right, we're going to shift gears now to States 144. With regard to this piece of evidence, again, just to be clear, did you perform both the RSID saliva test and the Lugol iodine test on the cuttings from this item, ma'am?
Yes, I did.
Okay. And as it relates to the RSID saliva test, what was your result?
It was a negative RSID saliva test. No indications of saliva were detected.
You may.
On this is States 146. Do you recognize that?
Yes.
Is that a fair and accurate portrayal of the cassette in which you performed the RSID saliva test on States 144?
Yes.
I move to tender States 146 at this time.
Any objection? It is admitted.
And did you also perform the Lugol iodine test on States 144?
Yes.
And what was the result of that test?
Greater than 10% of the cells stained the chocolate brown color, so the indication of vaginal epithelial cells were indicated.
And like before, did you take a picture of the slide with which you made that determination?
Yes, I did.
If I can approach one more time.
You may.
This is States 135. You recognize that?
Yes.
Is that a true and accurate depiction of the slide that you created and observed after running the Lugol iodine test on States 144?
Yes.
I would consider that exhibit at this time.
Any objection? It is admitted.
And if I could publish these to the jury.
You may.
All right, this is 146. Again, is that just, oh, that's upside down. Is that the RSID saliva cassette that you used in examining States 144?
Yes.
And it just, again, to be clear, what was the indication on that test?
The
Positive or negative?
negative.
And how are we seeing that here?
There's only a singular line at the control line and not a line at the test line.
States 135. And again, just to be clear, is this the picture of the microscopic slide after running the Lugol iodine test on States 144?
Yes.
And what are we seeing here?
We're seeing greater than 10% of the cells have exhibited a chocolate brown staining, so that's why it was considered a positive indication.
Based on your training and experience, coupled with the results of the testing that you performed on States 143, which is GBI item 2I, that testing to include both the RSID saliva test and the Lugol iodine test, if I were to tell you that that sample came from an oral swab, would that be consistent with your findings?
Yes.
As it relates to States 144, your item number 2, GBI item 2J, again, based on your training and experience, coupled with the results of the testing that you performed on this piece of evidence to include both RSID saliva and Lugol iodine, if I were to tell you that this sample came from a vaginal swab, would that be consistent with your findings?
Yes.
And lastly, in connection with all the testing that you've described here this morning and the slides and cassettes that we've all gone over, did you have an opportunity to prepare a report that summarized those findings?
Yes.
If I can approach you on.
You may.
All right, this has been marked States 133. Is that just a copy of the report that you generated in connection with this case?
Yes.
I move to tender States 133.
Any objection? Any response to the objection of hearsay?
There you go.
It is overruled and admitted over objection.
Ma'am, those are all the questions that I have for you. The defense counsel may have some questions.
Mr. Cruz? Yes, go ahead, sir. All right, cross-examination, Mr. Cruz.
Ms. Lycone, good morning. My name is Attorney Ahmad Cruz. I have the privilege and honor of representing Mr. Edrick Faust. We previously had opportunity to speak yesterday. Is that correct?
Correct.
Okay. And would you tell the jury, is it true that you would agree that you're from California? Is that right?
Yes.
Okay. And the state of Georgia brought you here from California to testify about the testing that you conducted in this case. Is that correct?
Correct.
Okay. And if you know, other laboratories in the United States conduct RSID saliva testing. Is that right?
Yes.
Okay. And even some laboratories in Georgia. Is that correct?
I don't know.
That's fair. Other labs also conduct the Lugol's iodine test. Is that correct?
Correct.
Now I want to ask you this. You've been doing this since 2022. Is that fair?
Yes.
But you have never been asked to come into court and testify to the Lugol's iodine test. Is that right?
Correct.
Okay. And I think we agree on this. So this is your first time being asked to testify on these presumptive tests.
Correct.
Okay. How about the RSID test?
Is this my first time?
Correct.
Yes.
Okay. So no other state has said, hey, can you come testify about these presumptive tests to a jury?
Correct.
And neither are confirmatory tests. I think, excuse me, there aren't any confirmatory tests for these two tests. Is that right?
Correct.
Now I want to ask you this. You were given some packages that involve swabs. Do you still have those up there with you?
I don't.
I'm going to give you a pair of gloves.
Okay.
Just keep it going, defense. These are good questions.
Let the record reflect that I've given Ms. Lycone a pair of gloves. I've given her State's Exhibit 141. I am also going to give her State's Exhibit 142 and a pair of scissors. All right, Ms. Lycone, can you open the two packages that you have?
I am going to object to the relevance of having this witness open that package, especially in light of what happened yesterday.
Mr. Cruz?
Sure. The state introduced those items as exhibits. I believe we expressed on the court before that it's the items that's inside that is relevant. We just want to see the items that's inside, so I can ask her some questions about that.
I'm going to take a step outside the presence of the jury, and we are going to have a restroom break. So if you'll go into the jury room, this will be a restroom break. Mr. Cruz, I'll certainly give you one as well. At least don't discuss.
This motherfucker, honestly, if this was the role reversal, they'd be overruled. Carry on. This is every single freaking time she does this to the defense. There's nothing wrong with her opening it. Fuck. I'm fucking pissed all of a sudden now. I was so calm and happy just now. Now I'm bloody pissed again.
The case. If you'd like to do that first and come
Fucking
back, that'd be fine.
bitch.
Thank you, Your Honor.
Go ahead.
Fucking cunt. Fuck. Fucking hate this bitch. They submitted 3 items before, and there was nothing in the bloody things. Do you remember the 3 envelopes when there was literally supposed to be 3 hairs in them, and there was no hairs in them? So, sorry, Your Honour. Yes, I want to open them. Why? Because last time we opened envelopes, there was evidence missing. So, excuse me, Your Honour. I want to frigging see what's in there. If you enjoy the stream, please hit the like and subscribe button. I appreciate you. Thank you very much. That is the most ridiculous thing. She never does this to the state. Never. Every single time. I mean, how this defense attorney, Cruz, is keeping his composure, I don't know. I'm so pissed off for him. I'm so pissed off for the defendant. It's just... It's not even close. This is the most corrupt trial I've ever seen in my life. I mean, I literally... Nothing comes close to it. And there's a lot of corrupt trials out there, but this is the main one. Fuck. Who's the new attorney he's got? I don't know who the new attorney is. Yes, Bryce Steele, especially. Bryce Steele is his mentor. Just sit down there, Brian Steele, and friggin' counsel him. And be like, it's right, dude, you're doing a fucking great job. This bitch is trying to fuck you over. I mean, just cuff him now. Just cuff the defendant now and take him to the fucking jail. And then just process him and put him in prison, because that's what she's doing right now. I know I'm over-exaggerating. I know. I am over-exaggerating. I know. But I'm allowed to. It's my party. I'll fucking cry if I want to. Sorry, I don't mean to swear. I'm going over the top now. I don't need to swear. But I am livid. I am really pissed off right now. So, Dave, fuck off, Dave. Go and get your shower. Dave has showers once a month. So go and have your shower. Your wife will thank you. Oh, it's so frustrating. Like, genuinely frustrating now. Have I... Yeah, still playing. I just feel so sorry for the... What do you think the defendant feels like? He must be so despondent right now. He just must feel like the whole world's against him. Because literally, he's not entitled to a fair trial, apparently. Right, the bitch is back. Fucking...
Before we begin, now that we're outside the presence of the jury, anything further from the state about the objection?
No, it's just a relevance objection, Your Honor. I mean...
Fuck off the irrelevance objections, changing stuff now. Shut the fuck up. You objected, and you should not have done that, because you're a piece of shit.
Ms. Lacan testified that she received those items sealed, and then, open them to conduct the testing that she described. I apologize, I have a lifesaver in my mouth. I didn't know we were going back on the record so quickly. And I just can't see the relevance of actually having her open that. I don't see how that's going to be, make any material fact more or less likely for the jury's perspective. And then I also, again, in light of yesterday's incident with the slides, it seems like a bad idea. And so legally speaking, I would couch it in the form of a relevance objection.
All right, thank you. Thank you. Mr. Cruz.
Excellent. I think the state is precluded from arguing relevance because they introduced the items into evidence. As your Honorable Court is aware, I before have asked the state, before they introduced any of it, I believe I asked Mr. Yalamachili when he showed them to me, to open the package. I believe I raised an objection with the Honorable Court. We don't know what's in the items, and I think it's even more relevant the fact that we had one incident where we opened envelopes and they were...
Hang on. So the defense haven't even seen. What the fuck? They've literally not... I thought at least they'd seen the evidence and they just wanted the jury to see it. They haven't even seen what's inside these things. What the fuck? Are you kidding me? So literally the defense have not even seen what's inside them. Oh my, no way. Shut the fuck up. No way.
Completely empty. So what's in the package is relevant in this case. I'm going to ask her, are those items she tested? And I'll go down that line of questioning once she's able to identify what's in the package. As of right now, the state is just presenting packages saying, hey, take it for what it is. That isn't authentication. We want to authenticate these items and then ask the witness questions about those items.
All right, thank you.
But I won't pass it to the jury. It's solely for...
Okay, well, let's talk about that moment. All right, hang on just a minute. Mr. Bill, is there anything else?
No, Your Honor.
Okay, thank you. Hang on just a minute.
Don't you fucking dare hang on. If you do not let them open these packages, then get the fuck off. Oh my God. What? She laughed. He said, I won't show it to the jury.
All right, thank you very much. All right, I'm going to overrule the objection and allow Mr. Cruz to ask this witness to open the package, but I'm not going to allow it to be sent to the jury. I think that incident yesterday is indicative of the danger of doing that. There are methods if the jury wants to look at evidence that is sensitive, particularly during deliberations, and we take it up in the courtroom, we deal with it in that manner. I'm not necessarily making a finding that this is actually relevant, but you are on cross-examination. I'll allow you to do that. All right, anything else? All right. Well, I did tell them we had a restroom break. Can you knock on the door and see if they're ready? Thank you.
So, I'm not seeing how this is relevant. Judge, have you not been sitting there for the 5 days, and especially the day when the 3 envelopes did not contain the evidence that the state said that was in there?
All right, very good. Be at ease until then, until we're ready.
Is she crazy? She doesn't find any relevance. And I'm not giving them back. If they're safe, why can't you give it back to them? Not that it matters really. You just need to show them. Wow, I have not even she literally, if she could have, she would have literally not allowed that in. And why the state not wanting to show them? Why are they not authenticating all these? If you got an issue with Mr. Cruz doing it, then you do it. You do it, then state. It seems that the state are just doing the whole trust me, bro. There's evidence there. Trust me. Mr. Cruz is doing it, going, well, where the fuck is the evidence? Because there's 3 envelopes missing with hairs missing. Now I've got a high pitched voice, I know, but now they don't want to. They say, trust me, bro. These are the evidence that she tested. You know, no. You've lost 3 hairs. You've lost the window, whatever you call it, bloody thing to the house. It was a hair. It was a hair, it was. But there was nothing damaged. It was nothing that came out. It was fumbled, but nothing came out. The state just made a big fuss about it for no reason. I do sound like, and this is my pissed off voice. I am genuinely, if you want to see how mad I get, this is how mad I get. I don't get mad very often, but this is me at a very mad state. I literally would be shitting a brick if I was a defendant right now. I mean, look, I cover so many trials and I do get passionate about them, and this is one I never thought I'd get passionate about because I wasn't interested in this trial. But now I'm interested because I literally think this guy's been railroaded by the state and by the witnesses, by some of the witnesses who want to give additional answers to simple yes or no questions, and also the judge. This is like Aunt Bev has got nothing on this judge. And if people don't agree, then fine. But literally, I'm telling you, Aunt Bev isn't. She's like an angel compared to this judge. She's probably texting the state going, "Hey, just object again, so I can make sure you object again, so I can make another ruling and deny the defense. Keep objecting, guys. You're doing well." I can't comment about Gull because I didn't see it. I have not seen any of it. It wasn't televised, so that's why I'm not commenting on Gull, because I wasn't there. I didn't see it. I can't speak of it, so that's why I'm only judging against Judge Bev, because she was also really bad, but this one is much worse than her. So I can only comment on that. But others can obviously comment about Gull if you saw it or seen it or read the transcripts, but I can't, unfortunately. Or fortunately, because that would probably drive me mad as well. Oh, my days. I hate being dramatic as well. I hate being dramatic. I'm just staring her down. I'm just like, what's she doing? And just remember, I understand that Attorney Cruz is not for everybody. I get it, and sometimes I do think he's taking it too far. But his frustrations, I can't fault him. I don't think I could keep myself as composed as he has in his defence. I actually think he's been very composed throughout, even though sometimes I wish he'd sit down, but I'm not in his position to judge. And if I can act like this and I'm not even in the courtroom, imagine how he feels inside seeing this done face to face. Every hearing, every motion, everything is just like, nope. State wins. It's like, how will we even at trial when you consider the amount of evidence that's missing? I think it's just like people like, his mentor Steele and stuff, they've probably spoken to him and been like, look, you need to keep composure because the jury is seeing this. So, I think he probably knows the jury is seeing this. So I think after the first day he was just like, wait, it was bad, but now I can understand a little bit more his frustrations because we didn't hear the pre-hearing stuff. Now I think he's been very, very composed. Day 3, 2, 3, and 4, and now day 5. So, yeah. I don't know. Fuck, I just always go back to thinking this could be me, you, our family members, everything, and with good conscience. This is why I like to go to trials with the presumption that the defendant is innocent. I know a lot of people always make their minds up. I know a lot of creators go in always thinking that the defendant's guilty, and lots of creators think that it's up to the evidence to prove that he's not guilty. And I've heard plenty of podcasts and YouTube videos from other creators who will submit stuff and go, this is the evidence that's out there, so the defendant is guilty. But I like to always wait until trial, because that's where you get to see all the evidence. And that's why every defendant should be innocent unless proven guilty. And that's why I'll always try and be like that, because it's never fair. You don't know what they're facing because of some of the bullshit judges, that what they let in, what they don't let in, what prosecutors leak to the media and show to them as well ahead of trial. So I don't know. Now the jury having a piss, and they're taking the piss. I've never seen any trial with these many breaks as well. and it's always the same that because to me it somehow makes the defense look incompetent because she always sends the jury home back out like, oh, we can't do this in front of the jury because they might see the defense speaking sense, and I might not come across as being genuine in front of the jury, because at the minute they probably love me is what she's thinking. Oh, thank you, Lady. Well, I think your 10 minutes is up, Lady Di. I think your 10 minutes is up. Take it to the bar. Take it anywhere, because, after this... I'm just worried that this defendant's going to be... Like, there's more evidence to come. I'm not going to say that he won't be found guilty. There's more evidence to come in here, right? We don't know what the evidence is going to come in. And there might be evidence that shows that he is guilty. That's fine. If that's the case, that's fine. But let him have a fair trial.
Now that we're back on the record, I do want to tell everyone in the audience, since we have a number of people in here, and it's gotten busier since we started. It's on silent, please. Thank you. The other issue that I want to bring up for counsel with regard to the ruling that we just made is I think it is probably best, and I'm going to make this part of the order, that only this witness handle the actual contents of the actual exhibit.
Yes, ma'am.
All right, thank you. You may bring the jury out.
He never asked us to handle it. It seems like she always wants to have a one-up to go, well, I've let you have this one thing, but just so you know, you are not to handle it, Mr. Cruz. He never fucking asked to handle it. It's different if he went over there and said, hand it to me, but he never did. So shut your pipe hole, Judge. I hate this judge so much. I'm going to just shut my mic because I'm pissed off. I might just go on the sofa and watch it because she's pissed me right off.
All right, you all may be seated. Thank you. Mr. Cruz?
Okay. Thank you, Your Honor. Can you open the 2 envelopes that were provided to you?
Yes.
Can you hold it up?
Yeah. Do you want me to do one at a time, or?
Please.
Okay. So this is cuttings of item 2I.
And may I approach, Your Honor, just so I could get a better sight on it?
You may.
And then this is cuttings of item 2J.
Now, you'd agree that the items that you received were cuttings of swabs. Is that correct?
Correct.
Okay. Inside of the tubes that you have, do you recognize those swabs as what you tested?
Yes.
Do you know where those swabs came from?
No.
The only information that you had about the swabs were that they were oral swabs. Is that correct?
Correct.
Okay. At any time were you advised that the swabs were over? Well, let me ask this. What year did you test these swabs?
In 2024.
Do you remember what month in 2024?
I can see on the envelope it was October of 2024. I tested them.
October of 2024?
Yes.
Okay. Were you aware that these swabs were collected close to 23 years, well, past 20, close to 24 years prior?
At the time, no.
items that you tested, you don't know when, or excuse me, you don't know when they were collected. Is that right?
Correct.
You don't know where they were collected from. Is that right?
Correct.
You don't know who those swabs belong to?
No.
Okay, so you weren't given any of that information?
No.
You simply received a package labeled oral swabs.
Correct.
Okay. And question for you, you have the swabs up there with you. Would you agree that the, I may say this wrong, but the swabbing material, the cotton, in some places is pretty much white. Is that fair to say?
Yes.
Did you know that those swabs that you tested had been considered oral swabs for close to 24 years?
I would object to the characterization in that question.
All right. Most specifically, what's your objection?
I would object to the use of the word considered oral swabs versus labeled oral swabs.
I'll allow it, but you may follow up if you choose to do so with any redirect. Go ahead.
Sorry, could you repeat the question?
Sure. Were you aware that the items that you received had been considered or labeled oral swabs for 24 years?
I was not aware of the past characterization of them.
Okay. So is it fair to say that as you sit here today, you don't know if the swabs that you tested are the same swabs that were collected?
Correct. I'm only aware of what we received at our laboratory.
That's fair. Course indulgence. My last question for you. You mentioned this is your first time talking about these tests. Are you aware of anyone else being asked to testify about the Lugol's iodine test in court?
Sustained.
Those are my questions. Thank you so much for your time.
Any redirect, Mr. Bolden?
No, Your Honor.
May this witness be excused.
Please.
Any objection from the defense?
No, ma'am.
You are free to go. And you may call your next witness.
Thank you, Judge. I think that myself and Mr. Cruz need to review the exhibits that are going to be used with the next witness.
Okay. How much time do you need to do that?
I mean, a couple of minutes, Your Honor.
All right, go ahead and just do that. All right.
And if it's okay with the court, just to allow us to speak a little more freely about it, all right, Mr. Cruz and I stepping into the hallway.
Yes, that's probably best. Thank you. We'll be at ease, everyone. If anyone needs to use the restroom right now, certainly you can do that, but we just did take a break, so we're going to stay seated for just a moment.
What's happening? I don't know. Are we on a break again or what? Oh, she's gone off. Fine. That's what I was thinking. What was happening? Yes, they're wrapping up at before 2:30. They have to leave before 2:30 today. So, just to remind everyone, we are finishing at the latest, I believe, 2:30. So, whether it is bang on 2:30 or whether it's before 2:30, I don't know. So, yeah. So, the next witness should be the guy from last night. Oh, sorry, this morning, sorry. I'm confused. Yeah, it's Robbie G. Badaza. Yeah, it's either going to be 2 or 2:30. The that person in the juror needs to leave by 2:30, so it might be 2. Marky said, Dylan, I won't fix this judge with your dick. She sucks. Nothing wrong with a good sucking, Marky. But yeah, we'll give a bad dazzers. Why are we waiting? Oh, okay, I'll just go back and see because I don't know why we're waiting.
And you may call your next witness.
Thank you, Judge. I think that myself and Mr. Cruz need to review the exhibits that are going to be used with the next witness.
Okay. How much time do you need to do that?
I mean, a couple of minutes, Your Honor.
All right, go ahead and just do that. I mean, all right.
Okay.
It's okay with the court just to allow us to speak a little more freely. That's all right.
All right, so that's what they do it. Fine. Sometimes it's just easier to find out myself rather than asking chat. It's good. So we've done that. Right, so we're just going to wait for that now. So this witness, yeah, it was the one that was from this morning. You won't even use Mighty's. Mighty's lost the weight though. Mighty Meat lost a lot of weight. I'm not sure if he's gained it back or not, but he lost a lot of weight. He asked to do that the other day and they said it had to be done in front of the jury. Now he doesn't. No, so what they're doing now is they have to redact some stuff. So, what they were trying to do the other day was, so they're not submitting anything. They're just going through. So the judge has ruled that they have to redact some of these items. But she said that you can't put them in until they're redacted, so that's what they're doing. And then they will be submitted in front of the jury then. Oh, Dave. Jeepers, Dave. You had to take your right there, didn't you? No, I think he's just been exercising, looking after himself. He's got a young family, so I think he wanted to just get better, healthier.
Your Honor, I think we're going to have to address something with the court.
All right. Ladies and gentlemen, I am going to ask you to go into the jury room. Please don't discuss the case. We'll be with you shortly. Thank you.
So what happened the other day was they were going to put evidence, look at it. This is about redacting it in before it's put in because they can't put it in. They cannot present it because if it's presented as it is now, they'd have to object to it. So that's what they're going to do now. They're objecting to it now for something, whatever that is now.
Y'all may be seated. Thank you. All right, go ahead.
Thank you, Your Honor. This goes back to some pretrial rulings by the court based on the court's ruling and the defense's proffer that pursuant to the state's sodomy motion that Mr. Melton would be the only alternative suspect raised by the defense. The reports, beginning with State's Exhibit 136, makes reference to an individual as a suspect who is neither Mr. Faust or Mr. Melton, and so the state would seek to redact that pursuant to the court's order. It's not relevant, and under 403 would be confusing to the jury. As it relates to State's 137, same thing. There's an individual listed as a suspect who is not one of the noticed individuals from the court's ruling on sodomy motion. 403, again, it would be excluded. I don't know that the state is going to get into, 138, yes, again, same individual's name needs to be redacted in the suspect line. As it relates to 139 and 140, Judge, there are a number of individuals' names on here that kind of fall into that same category I was speaking of previously. They are not Mr. Melton or Mr. Faust, and thus their names need to be redacted pursuant to the court's ruling because it would be confusing the jury under 403. So that would be the state's position, and I understand after discussing that with Mr. Faust, the defense is not in agreement as to that.
All right, thank you. Mr. Cruz, anything, sir?
Yes, ma'am.
All right.
A big portion of this case is the police's investigation and the way that investigation was conducted. Our position would be that other suspects that were looked at should be considered by the jury as opposed to making this case solely about Mr. Melton and Mr. Faust. As I stated in my opening, Your Honor, the jury's job isn't to determine whether or not Mr. Melton committed this crime. The jury's determination is to determine whether or not the state has presented enough evidence that Mr. Faust is the person that committed this crime. I do believe that in regards to the 401 objection, it is relevant. Law enforcement looked at other individuals. I believe in the reports, since I'm making the argument, they look at other individuals, but they don't have their, in this particular case, hair fibers, because it's hair, their hair, because these are hair tests. They have these individuals listed as the suspect, but they don't have any of their biological material. So it is relevant. I don't think it'll confuse the jury because, again, as I explained to the court, you have this person listed as a suspect, but in the report you don't have this individual's biological materials. So I would ask the Honorable Court to allow or restrict the state from restricting that individual's name off of the testing form, Your Honor.
Thank you. Anything further? Mr. Yalman-Chile, it's your motion.
I think the law stands for a contrary proposition, which I argued to the court.
All right, thank you. So, Mr. Cruz, your argument is in direct violation and contradiction to all of the orders that have been entered in this case. And I've said many times, and I will say it again today, that the defense had the responsibility, if it chose to enumerate other possible suspects, that not only did they have to, by law, provide the proper notice to the state that they were going to seek to introduce evidence as to other persons, but also a hearing needed to be scheduled pursuant to that notice. That notice is in the form of a motion. And we've talked about this many times. That has not been done by the defense, with the exception of Mr. Melton. And we had that hearing. And that evidence that both parties sought to admit with regard to Mr. Melton was agreed by the parties and accepted by the court that would be admissible. I mean, not all of it, but just in general. But any other mention of any other suspects or things of that nature were prohibited based on the rulings by this court in several hearing days that we have had. And so I say that again to say that because of those rulings and because of the legal procedure that was not enlisted by the defense to get the proper permission to be able to talk about other possible suspects, it is prohibited. It is also not relevant based on the prior rulings. I agree with the state that under 403, confusion of the issues would be paramount in this moment. And so I'm going to order the state to redact those particular exhibits. I think they're 136, 137, 138, 139, and 140. Am I right about that?
Yes, Your Honor.
All right. I'm going to order the state to redact those exhibits, as we previously discussed, with regard to those rulings. I mean, I think that's, we've kind of gone over this.
May I respond, Your Honor? I'm happy to heard. And I believe I may have explained it wrong. I am not saying that we want to say that this third person did anything. We're saying that it's relevant because it goes to law enforcement's investigation. And please forgive me for not, I probably didn't state that the first time. But they're saying, hey, this person was a suspect. However, the test is biological testing. The relevance for us is we're showing law enforcement said this person is a suspect, not because we're saying they committed the crime. We're saying look at the work they did. Person A is a suspect, but they don't have any of person A's biological material. And please forgive me if I misstated that the first time.
Well, I did actually understand this part of your argument.
Understood.
I did, and with regard to the comments you're making about the police work and how they conducted it, I'm not making a finding about that issue. But my ruling stands.
Yes, ma'am.
Because the defense has failed to provide the proper motion and notice that the law requires in order for the court to then make a determination as to even whether that evidence should be admitted. And so because of that, regardless of the reason that the defense or any party wants to introduce that evidence, it is prohibited.
Yes, ma'am.
All right, thank you.
Thank you.
How much time do you need, Mr. Yelman-Chili?
Just a couple of minutes,
All right.
Judge, and then I'll hand it to Mr. Cruz
Okay.
to make sure he has no objection as to form. I
All right.
understand he objects in general.
Okay.
And then one request I would make of the court is, we can redact it for today with a Sharpie. We also have the ability, though, to black it out digitally and then reprint the report with that blackout. And so at the appropriate time, I'd ask to, I guess, submit an alternative redacted version of the exact same report. Obviously, it's just a digital file at that time.
All right. I guess my question for the redaction process is, do you need to make a copy of that exhibit and then do it, or?
I think it's fine.
All right, I'll just leave that to you. We
Thank
just
you.
need to make the record clear. All right, we will take a 10-minute recess. I'll be back on the bench in 10 minutes. Thank you.
I mean, jeepers. She just likes to give a lecture. I mean, I believe she is right in her ruling. I mean, they should have put something together. She's stated that many times. I just don't think she needed to lecture him on it, you know. Welcome, Reese. That was Lady Di, and there you go. Glad you got a gift membership. And hope you are well. Lady Di, why is Dave saying something to Lady Di? That always worries me when Lady Di and Dave are conspiring. You were supposed to go give the judge some more last night. Okay, now I know you're talking shit, so it's fine. I just sometimes feel like she's talking down or speaking down to Mr. Cruz. But, you know, anyway. Oh yeah, no, not today, Monday. How many more witnesses do we think? Oh yeah, Chris has got to come back on, isn't he? Chris has got, but is the state going to call Chris, which I presume they will have to, or the defense going to do it? Because obviously, if the defense do it, then the state get to cross-examine. So they may, like, it would make logical sense for them to do that, but then what would the jury think about them not calling? Why are they not calling Chris? What have they got to hide? So that could be another reason. And just put pressure on the defense then. Well, you know, you're pitting Chris against the defendant, so you bring the guy in. We don't care. So that could be a logical thought process. It might be worth that risk to do that, potentially. Rhonda, I hope you're well. I did ask this morning. I hope the doctor went well with you. You weren't here first thing when I did ask. I hope everything went well with you, Rhonda. Bad Dad says, sorry, hun, I have standards. Bad Dad, do me a favour and stop lying in chat, please. You do not need to lie in this chat, Bad Dad, as we all know you by now, sir. It is all gravy, baby. So, yeah. So somebody said yesterday, the judge said this trial lasts 2 weeks. I think that was probably before all the stoppages. So, and the defense have got a case in chief to put together, they said. So, how long is that going to last? How long's a piece of string, I suppose. And why don't Cruz just file for the hearing and do what she says to satisfy the law? That's what I mean. That's what I'm saying. She was right that it had to be marked out. So I don't know why he's not. There must be a reason. There must be some sort of. I think the reason probably is that he just wants to concentrate on Chris, the boyfriend, and does not want to introduce other people because probably there's no reason to. Because they got so much on Chris, and the other people, they don't really have anything as a, to showcase that it could have been somebody else that did it. Whereas they got stuff against Chris. So. But there's a line in chat again, saying, I've always had standards. I used to drink a lot back then to lie in again, Badaz. Badaz, we respect you because you never lie, but already you've said 2 lies that you have standards. Twice you've said that lie. So if everyone is enjoying the stream, hit the subscribe and like button to help me out, please. If you're not liking the streams, then still please hit the like button to help the stream. So that's whether you like it or not like it. If you can hit the like button, that would be much appreciated. Thank you to those that have liked already. I know a lot of people have since left, but thank you if you do watch this on replay for coming in and hitting the like button. It is appreciated. So, 10 minutes, she said. 10 minutes, she said. That was 5 minutes ago, so we're halfway through. We're halfway there. Oh, living on a prayer. Da, 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 da. Okay. Move that there. Done. Right, what else is going on? What else do we want to talk about? Oh, what was there's a new trial. What's her name? Daisy something? Daisy Link? Is it Daisy Link? That's called a new trial. They planned 2 weeks. Oh, was it you, JLK Upstairs? They planned 2 weeks, then told judge 4 to 6 weeks. Judge said, no way, we're going to come in at 7 a.m., stay till 10 if we're going to get... we getting it done. Nope, out at 2 p.m. today. This is going to be 4 months. I hope not. Well, in defense, I will defend the judge here, JLK. The reason they're finishing early is because of a juror, because a juror needs to be somewhere by 2:30, which the court was made aware of at the beginning of the trial by the juror. So today was always going to finish at 2:30. So just that I will defend the judge on that one. That this is not her call. This was the juror's call. Solid defense opening statements. Oh wait, play the shut the fuck up video for JLK. I have to open files for it. I can't play them anymore. I have to go into files and play them. Hang on, let's see if I can find it. They're not on my like with StreamYard. I can just press them. On these, you can't. You have to then go have them all lined up and everything. Let me take a look to see if I can find one. They're not as easy anymore.
Hey man, just want to let you know that sometimes you gotta shut the fuck up. And this current time is just one of those times you gotta shut the fuck up. I don't think you're a bad person. I just don't want to hear you talking anymore. You gotta shut the fuck up.
Erin Hartree drives a bus, yellow bus, yellow bus. Erin Hartree drives a bus all day long. Hippie chick, lady di, spacey Stacy, walking those streets all night. You go, ladies, come and see what's going on now. Let's go, girls. Josie and Murph, they aren't as lovely. Fuck around and find out I'm joking, they're lovely.
Great tits. Great tits. Great tits.
Zara P, Zara P, Zara P, 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 Zara P, Zara P, Zara P is lovely.
You're a cunt.
You're a cunt. You're a cunt. You're a cunt.
You're a cunt. You're a cunt.
You're a cunt.
You're a cunt.
For DNA analysis, for mainly for identification purposes. Excuse me.
Is the femur a good source of DNA for some reason?
It is.
He burped. Hang on. Let's go back. He burped. Oh, that's funny. That's a nightmare. That's that's a nightmare for anyone. That'd be my nightmare to, fart or burp or something. He just burped. Oh, how fucking childish am I? Oh.
For DNA analysis, for mainly for identification purposes.
If you don't find that funny, I can't help you. Oh, that's hilarious. Oh, fuck. I'm sorry. Go back and watch it again.
That bone, release it to law enforcement, and law enforcement would then send it to a laboratory for DNA analysis, for mainly for identification purposes.
Oh, what a poor guy. Oh, poor guy. Let's go back again. Hey, Katie. Katie Santos in the house. Oh, Katie, watch it. He burps. Hang on.
That bone, release it to law enforcement, and law enforcement would then send it to a laboratory for DNA analysis, for mainly for identification purposes. Excuse me.
What's going through his head right now? What's going through his head right now? He just burped. He must be so embarrassed. Oh, that's funny. That's funny. Oh, I think that's hilarious. I think that's hilarious, everybody. He just fucking burps. That's just a fucking nightmare. Anyway, sorry. I'll get back.
He says that happened in 2018. The cement slab is poured in 2016. The body is already there under. That trespasser has nothing to do with this. Well, we know he's not sending the 500 pages.
Sorry, I'm bored. Did you not know, people? Do you not remember this story about Scott? Scott, was that? Do you not remember it? When Scott, we were here one night. Oh, I think it was Ashley Benefield. No, that might not have been. We were doing a long stream, and we were about to finish. I was like, right, I think we're done for the night. I think we're done. We've done like 12 hours or something. Right, thank you, everybody. I thanked everyone for being here. And literally, as I said that, Scott must have. I remember it. I was like, good night, everybody. And Scott must have written the chat. I pressed enter. As I was saying goodbye. And he came up and put a cross-dressing. Well, I'm not going to stop the stream. So we carried on for like a couple more hours talking about cross-dressing. Literally, the timing of it was like, right, good night, everyone. And then he posted it. and I saw my girlfriend, my ex, used to make me dress up. So then we go into the story. So I bring it up nearly every time now for Scott. That's hilarious. I love it. I genuinely do. Scott, I'm so sorry, Scott. Oh, shit. Hang on, I got Larry on the phone. I'll tell my husband to dress in lingerie just to see what he would fucking. I would do it in a heartbeat, so he would as well. Larry, you are live to tape. We're on stream, okay? So just hello, everyone. Yeah, we just we are. I've not checked in you all week. I was going to phone you this morning. Then I thought, you know what? We had a break, so I thought, you know what? Let's phone him now and see how he is. But then the trial's going on as well. So, but we still answer the call to you because you're the man. What's the topic of discussion today? Well, we're watching this boring trial, okay? So that was bad. What the topic of discussion right this second? I don't take this too far now, right, Larry? But this second is we're talking about Scott McGuinness cross-dressing, his and you would do it. So the scenario is this, right? So you bought your significant other, your girlfriend, right? Some lingerie and a corset and like nipple tassels to dress up in and stuff, right? That's what happened here, right? She wears it, you do the business, you get down dirty, you do the business, and then she turns around to you, Lauren, and says, right, okay, if you want to have sex again, you now have to wear the lingerie and the corset. Would you do it?
Well, the answer to that is no.
Shut the front door.
And one time I only bought lingerie for a girlfriend once.
Yeah.
And I'll tell you why. Because I went over, it was a Friday night, we had a few drinks, and I said, I gotta go out to my car, I'll be right back.
Yeah.
And I went out to the car, I got the bag, and I came in and I go, honey, will you put this on? So she looked at it and she goes, absolutely. And she said, she goes into the bedroom and she's coming out. She put the lingerie on, but you know what else she put on?
What?
A strap on. What exactly are you planning on doing with that? She goes, turn around and find out. I said, fuck you, and I ran out of there.
All right, we are back on the record. Has the state finished the redaction?
We have, Your Honor, there may be a separate issue that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with Mr. Cruz about it. It just came to our attention. But can we do that initially off the record or in chambers to discuss how the court wants to handle it?
Oh, fuck,
yes.
I'm crying. I was not expecting that.
We can do it in chambers.
Oh, fuck, Larry. That's not where I thought that was going. Oh, fuck, I can imagine you run out of there. Oh. Oh.
And I'm 6'2", 220. I was running like a little bitch.
Oh, I bet.
My ass was all tucked in. I was shaking all my
What was her size? Was she huge? Was she tall?
And she's like, come back, honey, come back.
Well, was she taller than you or something?
No. She was like 5'7".
Oh, fucking hell. What was it? What size was the strap on, though?
Oh, it was a big black one.
Okay, yeah. I can't. Oh, I can't. No, I would have run out as well. You just took that. You took a story about cross-dressing. You just doubled it up, times it by 10. Oh. Because I thought 100% you would. 100% you would. If someone said,
Absolutely not. I don't go for that shit.
not now, not with that story, no, but
Jesus Christ.
I thought.
Nightmares because I just told that story again.
You said it live as well. Everyone sees it on stream. Live. Well, that's what's quite cool here. If you all see this, this was given to me, sent to me by Sassy Bartender. That's quite cool. That, and I believe the card as well. Is the card? I need to look at that. But for sure, this was given to me by Sassy. So for those who don't know, Sassy Bartender died last year during the Karen Reid trial. Or just after, I think. And so yeah, she sent me that. Wow. I just blast from the past, that was shit. Right, I'm going to end that because we don't need to go into that. Right, let's go back a little bit here to see what happened. Robbie G, oh, she could just go live because there's nothing.
All right, we are back on the record. Has the state finished the redaction?
We have, Your Honor, there may be a separate issue that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with Mr. Cruz about it. It just came to our attention. But can we do that initially off the record or in chambers to discuss how the court wants to handle it?
Yes.
Okay.
We can do it in chambers if you want to do that. Let me see y'all dementia just for a minute. It can be on the record, it's fine. So, I'm happy to do it.
That sounds... No, well, that sounds more serious if they're having it initially off something's just come to their attention, so it's something that's just come up now. So he's showing the defense attorney it now. So he's been sent something. And they're probably going to go into chambers then. This might be a post seen on social media. A witness has said or done something. Just ask, where did he get that from? They're going to tell the defendant. I don't. So they've gone on break, and they've probably gone to chambers because, yes, they've gone to chambers.
Okay. Thank you.
Yeah.
Oh, no. Do you want to tell the judge that?
Okay. All right.
Oh, they don't just go to chambers for nothing. This is serious. This is fairly serious, I would imagine. Right, people said who's smiling. Right, I don't know. Let's go back and listen to that section all again. Let's see the whole section again, because I don't really know what.
Your Honor, there may be a separate issue that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with Mr. Cruz about it. It just came to.
You can see there, right. Hang on a minute. Let's try and do some detective work here for a second. Let's try and do some. I know I won't get a good picture here, but still. Let's do that. Again, I know this is not going to be a very good thing, but we will try our best here. Hang on. Hang on. So that's white. So it's some sort of picture that he has there. There doesn't seem to be any words at the top. So I presume that's a picture. Okay.
Our attention, but can we do that initially off the record or in chambers to discuss how the court wants to handle it?
It's a picture.
Yes.
There might be text with it, but it's a picture.
We can do it in chambers if you want to do that. Let me see y'all dimension check.
He's pointing, I presume, to the picture. The defense attorney looks worried. He does look worried because he's like, where did he get that from? So, yeah, they do not go into chambers for nothing. I hope I'm wrong and it's not.
Okay. Thank you.
Okay, let's go here then. To live. Okay. Mysterious. Mysterious girl, I wanna make love to you. Bow. That's Bad Dazzle's song. So again, this is what. No, that's the wrong one. I hate it when I bring the wrong one up. Let's. So you can see, as I say, it's not a great photo, I know, but it is something. Because, you know, that's... Hang on, let me go back a second as well. Let me go back a second, see if I can get a better...
With Mr. Cruz about it.
Okay.
And that we need to address with the court, though.
Okay.
And I haven't had a chance to talk with Mr. Cruz about it.
Damn, I missed it.
And I haven't had a chance to talk with Mr. Cruz about it.
Right, that's the angle I needed. I want to make love to you. Do, do, do. Do, 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 do. Hey, 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 yeah, 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 yeah. Bam, bam, ba, ba. No, you can't zoom in on stream. Ba ra 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 ba ra ra beep 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 ba ra ba ba. Oh, who's calling me? Hang on, someone's calling me. I am not going to answer to you, whoever the fuck you are, because I don't know. It's Chelmsford, but there's a. I don't know anyone in Chelmsford, but there's a. Ba-da, ba-da, da, da, da. Ba-da, 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 da. Beep, 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 beep. Hang on. Ah, get off my screen. Okay, sorry. I know it's a screenshot of the phone. I know. That's why I said to people, you can't zoom into it. That's what I'm saying. That's why I did it this way, because there's more chance of doing it this way. So photos at the bottom, and then a photo there. So it's just a photo. Whether it's a screenshot or not, but it's a photo. But we just don't know what it is. So no such luck with it. I can see the features of it, but I can't make out anything more than that. So I don't know if it's writing on the left or whether it's a blurred picture. I don't know. But that's the best I can get from it, and I can't make it out properly from that, unfortunately. It could for sure be writing on the left hand side, but it's not clear enough. But anyway, that's the best I can do, because you can't get closer than that at all. So no idea, people. I would tend to agree. Someone says screenshot. Yeah, I'm not doubting it might be a screenshot of some sort. But he did ask, the defense did ask, where did he get that from? And he was like, oh, I don't know. He just sent to us. So, like, I'm not a body language expert, but the defense looked a little bit more worried than the prosecution. So, is what I would say. They did look a little bit more worried. So, let me see if I can find something. Somebody, has found. It might be the judge's OnlyFans. They're like, oh no. Beep, beep. beep, 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 beep. Hopefully they come back and put it on record, so we'll find out. By the way, I'm not interested to hear secondhand from other chats and stuff, people, because no one, until it's not in court, we won't know. So it'll be purely speculation. Oh, they're back.
All right. We are back on the record. Before we get started, is there a Jessica Berryman present in the courtroom?
Here we go.
I hear no response. All right. Counsel for the state, are you ready for the jury to come in?
We are, Judge.
Mr. Cruz?
Yes, Your Honor.
All right. Thank you. You may bring the jury in.
Oh, it was a photo from the courtroom. What did you say? Jenny Berryman. She must have taken a photo in the courtroom and posted it. Which, obviously they can't do anything, but... Jenny Berryman, she's going to be all over Twitter now. Everyone looking who the fuck she is. Yeah, maybe, but yeah.
Please be seated. Mr. Yalamachili?
Thank you, Your Honor. State calls Larry Peterson.
Could you get Larry Peterson? Thank you.
Sir, if you would raise your right hand, do you swear or affirm the testimony you will give to the jury today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please state and spell your name for the record.
Larry Keith Peterson, LaryKeithPeterson.
And, sir, are you currently employed in a full-time capacity?
I am not. I'm retired.
All right. And when's the last time that you worked in a full-time capacity?
I was retired from the GBI Crime Laboratory in 2008. So I was employed there from 1978 to 2008. In 2008, I was employed by the U.S. Army Criminal Investigations Laboratory until I retired from there in 2017.
Okay. And going back to before your employment, what type of educational background do you have?
Yes, I have a Bachelor of Science in Forensic Science from the University of Central Florida.
And what was your first job after college?
Was employment at the GBI Crime Laboratory.
Okay. And so between the GBI and the United States Army, how long did you work in forensic sciences?
That would be almost 40 years.
And as it relates to, we talked about your educational background prior to starting work at the GBI. What type of training did you receive when you went to the GBI?
Right. So scientists at the GBI trained me in various aspects of trace evidence analysis. During my employment, there was also attendance to seminars and classes on the evaluation of trace evidence, including professional organizations and, personal relationships with other scientists.
Do you have any professional affiliations from your time working in forensic sciences?
Yes, I was and currently in emeritus status with the American Board of Criminalistics, also American status with the American Society of Trace Evidence Examiners. I'm a retired member of the American Academy of Forensic Sciences and retired and past president of the Southern Association of Forensic Scientists.
And as it relates to the Southern Association of Forensic Scientists, did you ever serve as president of that organization?
Yes, I did.
All right. Have you ever had any publications regarding forensic sciences?
Yes, I've published several articles on trace analysis.
And have you ever been recognized for your work in forensic sciences with any types of awards?
Yes.
Your last title at the GBI or job responsibilities, what was that?
The title was a microanalyst, generally a person who is responsible for evaluating what's generally considered microscopic or very small amounts of material.
Okay. Did you have any leadership roles as it related to your time in the trace evidence section?
For approximately the last 9 years, I was deployed with the GBI. I was the trace evidence, not supervisor, but I was supervising the competency as technical leader of the section.
And you said supervising the competency as technical leader of this section. Can you elaborate a little bit on what that means?
Generally, it's the person who is responsible for reviewing and generating revised protocols and procedures, and also oversees proficiency testing.
Okay. And have you ever testified as an expert in any fields?
Yes, I've testified on over 400 trials in various aspects of trace evidence.
Okay. And as it relates to various aspects of trace evidence, have you testified as an expert in the field of human hair analysis?
Yes.
Okay. And have you testified in the states, in the courts of the state of Georgia?
Yes, state courts as well as federal and military as well.
And Your Honor, at this time, I would move to tender Mr. Peterson as an expert in human hair analysis.
All right. Any objection from the defense?
No, ma'am.
This witness is qualified or tendered as an expert in human hair analysis. You may proceed.
Thank you, Judge. Mr. Peterson, next, I would like to talk to you a little bit about human hair analysis. And I would like to start with the science behind human hair analysis. Do human hairs contain any unique or variable characteristics?
Right. So the science of comparing hair is that a recognition that hair contains several basic parts. So there's a cuticle outer structure of a hair. There is the basic protein, the main portion of the hair called the cortex. Some hairs contain what's called a medullary structure, a medulla, which is kind of an air-filled tubular structure that can appear down in the center of some people's hair. So based on, and the cortex of the hair contains the pigment granules, which gives the hair its color. So there's an evaluation microscopically of all of these features, both from a gross microscopic or a low-power magnification view, as well as a detailed comparative, detailed microscopic comparison.
I can't pull Facebook up, but Robin G sent me the stuff. Yeah, I'm going to post it now, Erin. I'll show you the screenshot, people. Thanks to Robin G for sending me this. I'll post it now so you can all see it. She posts on TikTok and stuff apparently. Let me get it up for you, people. She's a fucking divvy, is what she is. Unless I could do it this way now. Oh, here we go. So this is her, what she's got up there, right? She's a fucking numpty. So, this is her. This is her. Jessica Berryman. She's got 8,500. 4.5 following. 41k post. Apparently she's on TikTok, and she's covering the case. And she's from the area, and she obviously heard it because she's like, Lisa, so judge is Lisa. Lisa, I'm at home in Loganville. Now don't be called my name like that. So yeah, she's obviously quite chillaxed about it, but I presume she posted something. It may still, somebody might have screenshotted it obviously, but or it might still be on TikTok or something, I don't know, but this is her. She does look like a TikToker, digital creator. There you go. And she is from the area, in fairness, so that makes sense why she's covering it. And she doesn't really give a shit because Lisa, my home in Loganville, now don't be calling my name like that. So there you go. So I suppose she won't be back in court, that's for sure. By the sounds of it, she will not be back in court. So, but my hunch is that she probably took a photo in the court, because what he showed showed because this is why the defendant was pissed. So the defense was pissed. You can tell that it probably did a picture of the defendant or something like that around the defense, and that's what they were showing, is my guess. So obviously you're not allowed to take pictures or anything in the courtroom. So silly Billy if she did that, but we'll see. It might come out in the wash. Anyway, who cares now? Anyway, it's gone. Right, let's get back to the trial and carry on. Here you go.
With a question and a known hair, an attempt to determine if there's an association between those two samples.
And so as it relates to the variable characteristics that hairs can have, are there certain characteristics that have a lower rate of occurrence and will be more unique as opposed to other characteristics that have a higher rate of occurrence and less unique?
Right. Some hairs possess fewer characteristics than others just based on the amount of features that are available in the hair. For example, a very fine diameter blonde hair would have fewer characteristics to observe than a larger, more heavily pigmented hair.
Okay. And as it relates to hairs, an individual strand of hair, is that uniform from one side of the hair to the other side of the hair?
No. In the examination process, it's understood that the root end, or what we call the proximal end of the hair, would have different characteristics as you progress along the length of the hair towards the distal or upper end. It's just a natural progression over time, how hair changes as it grows.
And now I want to shift with you to the process of conducting a hair analysis. Is there a scientifically accepted process for conducting that analysis?
Right. So as I described, so in the process of procedure, you would start with the mounting or the collection of the hair, whether it was submitted as a collected hair or it could have been submitted as an item of clothing or something else. And then hairs would be recovered in the laboratory. However that process happened, the hairs would be mounted on a glass microscope slide in a mounting media to allow for its closer examination, which would begin with the stereo or low power magnification, around 10 to 40 magnification. In that classification process, we can look at the overall length and color, the shape of the hair, give some idea of maybe some racial origin information, certainly body area origin as well, and can be the first step in the association or the elimination of a question hair from a known hair sample. So a question hair would be one of unknown origin. It's a hair recovered from a crime scene or something of unknown origin. And we would have known hairs, a collection of hairs that represent the known hair of a particular individual. That range of knowns would be fairly tight to one another, but even hairs collected from a single individual is not going to be identical to one another, but they're going to be very, very close in characteristics compared to known samples from other individuals. And so in the comparison process, it is if it's not eliminated at the stereo microscope, it's transferred to a comparison microscope, which is where light is transmitted through the hair samples on two microscopes. The two microscopes are hooked together with an optic bridge so that you can view the internal characteristics side by side. And at the end of that process, if following the examination of the hair from the entire length of the hair, if that question hair falls within the range of the known sample, we can conclude that that hair is associated with or could have originated from that person. If it fails in that examination at any stage, it would be eliminated as potentially originating from that person.
As it relates to this particular case and the murder of Miss Tara Baker, were you asked to conduct certain hair analyses as part of your work at the GBI in this case?
Yes, in 2001, I was employed by the GBI laboratory and performed examinations on the Tara Baker case.
Okay. And so what I'm going to do at this time, Your Honor, I'll show Mr. Cruz what I'm going to hand to the witness, but I'm going to hand the witness some exhibits that have already been admitted into evidence. Mr. Peterson, I'm going to hand you this little box lid that's full of some slides as well as some envelopes. Starting with the envelopes, do you mind going through those and taking a look at them?
Yes, sir.
All right. And so do you recognize those envelopes?
Yeah, these are samples submitted to the laboratory for analysis. They all contained a unique case number for the laboratory, 2001-1002454. And that was the case number associated to the Tara Baker case.
And what are the exhibit numbers on those envelopes?
We have defense exhibit, I believe that's 17, 16, and 11.
Okay. And let me ask you this. We talked about the process that the GBI lab goes through when hair analysis is being conducted. Is it the typical process of the GBI crime lab after a hair that's being analyzed has been mounted to remove it from its mounting, put it back in the envelope, and send it back to the law enforcement agency? Or is it the typical practice for it to remain on the mounting that it was placed on?
I will say this post is hilarious that she made. Jessica Berman, step on that oxygen cord, she's lying, get off the stand, stat. That is pretty funny, if I'm being honest. Hang on, let me see if I can make this bigger. That is pretty funny. I gotta give her that. That is funny. Hang on. I got that from Robin G. That is, you gotta admit that post is funny. If you got a sense of humor, that post is funny. Step on that oxygen cord, she's lying. Get off the stand, stat. Thanks, Robin. So obviously that was not done in court. That is funny. Right, here we go.
For analysis purposes.
Right. No, it would be left on the slide that it was removed to, and that would become its permanent status at that point.
Okay. As to those envelopes that I've handed to you, are they sealed or are they open?
They appear that they have been cut open from one end.
Okay. Do you see anything on those envelopes that would help you recognize whether or not you had ever interacted with those envelopes?
Well, yes, each envelope, in addition to the laboratory number, has my initials on the envelopes.
And what I'd like to do is retrieve those from you now, and Judge, I'd ask to publish them on the Elmo.
All right, ready?
And I'm going to start with Defense Exhibit 11. And I just want to point to one part of this. What is that my finger is next to there?
That's the initials that I use on evidence.
Okay. And Defense Exhibit 16. I'm going to flip it around the other way, sorry. What's that I'm pointing to?
Also on my initials.
And lastly, Defense Exhibit 17. And right there, what am I pointing to there?
Yes, my initials.
The hairs you received I think you already indicated those would be mounted. When they are mounted on a slide and then maintained in that medium, I want you to review now the slides that are in front of you and let me know when you've had a chance to look through all of those.
Yes, I believe these are the slides that I had earlier recognized, that these are boxes containing the prepared slides with mounted hairs.
And I'm going to retrieve one other thing, and then I am going to have some questions for you about that. I apologize. Should have retrieved these before I got you on the witness stand. Items now. And Mr. Peterson, I'm going to hand you those items now. I'm going to ask you the same question that I asked you about the 3 envelopes. Do you recognize those bags, is what I'll refer to them as?
Yes, sir.
And how are you able to recognize them?
Well, each of these exhibits contains the laboratory unique case number, 2001-1002454, as well as my initials on each item.
Okay. And did those appear to be in substantially the same condition as when you received them from Athens Clarke County Police Department?
Yes, there may be some additional seals, but the container itself is the same.
Okay. All right. Now, going forward to the slides in that box in front of you, you had a chance to review those. Do you mind telling the jury what exhibit numbers you are looking at?
Well, I may not say these in order, but I will just go down through the list of the boxes. So I have States Exhibit 124, 122, 125, 114, 117, 118, 121, 123, 119, 120, 116, 115, as well as Defense Exhibit 31.
All right. Thank you, sir. And I think, did you previously testify that these include the slides that you conducted your analysis on?
Yes.
Okay. Did you generate any reports in association with the analyses that you conducted?
Yes. I produced several reports.
I'm going to hand you first what I've marked as States Exhibit 136 after I show it to Defense Counsel. And I'll actually go ahead and hand you States Exhibit 137 as well. (136) first. Do you recognize what that is?
Yes, so this is an official report issued by the laboratory that shows the results of my examinations.
And what date is that report from?
February 2nd of 2001.
And does it appear to be a true and accurate copy of your report associated with your analysis on that date?
Yes.
And Judge, I move to tender 136 at this time.
Any objection? It is admitted.
All right. So looking at 136, does it have certain numbers associated with items that you received?
That's correct. So when evidence is submitted to the laboratory, it's given an exhibit number in addition to a case number.
Okay. And so those numbers that we're about to refer to, those would be, by your terminology, an exhibit number. Is that correct?
Correct.
Okay. Was there an exhibit number 2?
Exhibit 2 is a sexual assault kit, identified as that from Tara Baker.
And as it relates, was there an exhibit number 8?
Yes, exhibit 8 is identified as question hair recovered from the buttocks of the victim, Tara Baker.
And was there an exhibit number 9?
Number 9 was an item identified as question hair from the torso of the victim, Tara Baker.
And then where did exhibit number 10 come from?
10 is identified as question hair recovered from the left hand of Tara Baker.
It also, as part of this submission for your analysis, were you given known hair samples from any individuals?
Yes, that shows 5 known hair samples that were submitted on that same date.
And starting with Exhibit 21, whose hair sample was that?
Known head hair of Chris Melton.
And Exhibit number 22?
Known head hair of Christopher Hall.
And Exhibit number 23?
Known hair of Jeff Hall.
And Exhibit number 24?
Hair sample of Ashley Peavy.
And then Exhibit number 25?
The hair sample of Valerie Lang.
Okay. And as part of that sexual assault sexual assault evidence collection kit of Miss Baker, would there have been known head hairs as part of that kit?
Yes.
Okay. So now we got the known head hairs of Tara Baker, Chris Melton, Christopher Hall, Jeff Hall, Ashley Peavy, and Valerie Lang. Is that correct?
That's correct.
Okay. And then as far as hairs for which you are being asked to do a comparison analysis to see if there are any associations, you have a package identified as containing hair collected from the buttocks of the victim. You have package containing hair collected from the torso of the victim. And then you have a package containing the hair from the left hand of the victim. Is that correct?
That's correct.
Okay. I want to start with the comparison between the known samples in Exhibits 2 and 21 through 25 against the hair collected in Exhibit 8 from the buttocks of Miss Baker. Did you perform an analysis related to that?
I did.
Okay. And what, if any, opinion do you have based upon your findings as it relates to Exhibit 8?
Exhibit 8 revealed that there was one head hair microscopically consistent with the known hair of the victim, Tara Baker. There were 2 hairs inconsistent with the known hair of Ms. Tara Baker, and subsequent comparisons show that they were consistent with the known hair of Ashley Peavy.
And so let's talk about consistent with the known hairs of an individual. What does that mean?
It means basically that they had a correspondence in their microscopic characteristics, that in comparing the question hair to the known hair, they possessed sufficient similar characteristics to they could be included as a possible donor of the hair, that either would be from that person or another person possessing hair with the same characteristics.
Okay. And so as it relates then to Exhibit 8, and please correct me if I misstate anything about your findings, of the 3 hairs that were of a quality that could be analyzed, 1 was consistent with Miss Baker and 2 were consistent with Miss Peavy. Is that correct?
That is correct.
Okay. I want to go forward to Exhibit 9, which is collected from the torso of the victim. As it relates to your analysis on Exhibit 9, what opinion were you able to develop based on your analysis?
Exhibit 9 indicates that there were numerous head hairs consistent with the known hair of Tara Baker, the victim. 1 head hair inconsistent with the known head hair of the victim. And then further microscopic examination of that particular hair against the known hair of Valerie Lang showed them to be consistent.
So the hairs that were analyzed there were some that were consistent with Miss Baker, the victim, and then the one that was not consistent with Miss Baker was consistent with Miss Lang. Is that correct?
That is correct.
Okay. And so as it relates to the hairs that were found to be consistent with Miss Hall and Miss Lang that were recovered from Miss Baker's body, those were also compared against Mr. Melton, weren't they?
Yes.
Okay. And what was your finding regarding those hairs as it related to Mr. Melton?
Well, the hair was eliminated as potentially originating from him.
Okay. So as it relates to items 8 and 9, those hairs could not have come from Mr. Melton. Is that right?
That's correct.
Okay. And now I want to get to Exhibit 10, which is the hair from the left hand of Miss Baker. Based on your analysis of that hair, what opinion did you form regarding that hair?
The hairs identified from the left hand of Tara Baker, there were several head hairs and 1 pubic hair, all of which had the similar characteristics as Miss Baker's own hair.
So they were consistent with Miss Baker's hair, is that correct?
Correct.
And so that head hair, or I'm sorry, not head hair, that hair that was recovered from Miss Baker's left hand, was it compared with Mr. Melton as well?
Well, the head hair would have, yes.
Yes, and so that head hair that was compared with Mr. Melton, what opinion did you form as to whether or not that head hair could have come from Mr. Melton?
He was eliminated.
Okay, and what does eliminated mean?
Did not have corresponding microscopic characteristics.
Okay. As it relates, sir, to Exhibit 137, states 137, do you mind telling me what that is?
Again, this is an official report which I produced under the same case number 2001-1002454, the case number for Tara Baker, issued on February 27th of 2001.
And Is that appear to be a fair and accurate copy of the report that you generated based on your analysis on that date?
It is.
And Judge, I move to tender States 137 at this time.
Any objection? It is admitted.
And as it relates to States Exhibit 137, Mr. Peterson, it makes reference to Exhibit 2 again, is that correct?
It does, yes.
Okay, and Exhibit 2 is the sealed sexual assault evidence collection kit of Ms. Baker, is that correct?
That's correct.
Okay, and in there it has listed in Exhibit 12, what is that?
Exhibit 12 is identified as is a power transformer.
Okay, and did you have an opportunity to process that item for any kind of trace evidence?
Yes, hairs were recovered from that item.
All right, and so this power transformer, the hair that you analyzed that was recovered from that, what, if any, opinion did you form?
There were several hairs that were unsuitable for comparison. They did not possess enough characteristics to produce a meaningful comparison. In addition, there was one head hair which was suitable for comparison. And additional examination, comparison of that hair showed it to be consistent with the known hair of Chris Melton.
Okay. And so that's a separate thing than anything that was found on Miss Baker's body, though. Is that correct?
I believe so, yes.
All right. I want to go back now to exhibit number 10 in the hair that was in Miss Baker's hand that was consistent with her and eliminated Chris Melton. Have you had other occasions where you have examined hair that's been found in the hands of a homicide victim?
Yes, I have examined a number of cases, a large number of cases where hairs were recovered from the victim's hands, and the vast majority of time the hairs were always consistent with the victim's own hair.
Okay. So this finding wasn't an unusual finding then, is that fair to say?
It was not.
Okay. If I could have just a moment, Your Honor. Thank you very much.
Mr. Cruz, cross-examination.
Mr. Peterson, thank you so much for your time. The state asked you about the power transformer and the hair found on the power transformer. Do you remember that?
The notes reflect that it happened. This case happened a long time ago.
Correct. My question is, do you recall the state asking you about a power transformer and hair found on the power transformer?
Well, I mean, we just discussed it. Yeah,
sure.
Yes.
Okay, excellent. You don't know where that power transformer was located in relation to Ms. Baker's body, do you?
No, I do not.
I'd like to go over some of the hairs and the examinations you conducted. Is that okay?
Okay.
And I'd like to establish something first. So would you agree that Caucasian hair is different from African American hair?
I would agree.
Okay. And would you agree that based on your profession and expertise, it is easy, Caucasian hair is easily distinguishable from African American hair? Is that fair?
The vast majority of times, yes.
You examined a hair from the buttocks of Miss Baker. Do you recall discussing that?
Yes.
That hair was not consistent with African American hair. Is that correct?
That's correct.
You examined the hair from the torso of Miss Baker. Is that correct?
That's correct.
That hair was also not consistent with African American hair. Is that correct?
That is correct.
You examined hair from Miss Baker's left hand as well. Is that correct?
That's correct.
And you would agree that hair was also not consistent with African American hair. Is that correct?
I agree.
We discussed the power transformer, but you examined hair from the power transformer. Is that correct?
Correct.
Okay, and the hair on the power transformer was also not consistent with African American hair. Is that right?
That's correct.
And I believe you testified that the hair found on the power transformer was consistent with Chris Melton's head hair. Is that right?
That's correct.
You even examined the hair found on Ms. Baker's wallet. Do you recall that?
There was a hair identified as from the victim's purse, I believe.
From her purse?
It's identified as a purse.
Okay. And that was a pubic hair. Is that right?
No, I believe that was a head hair.
Okay. Your Honor, I would move to introduce Mr. Peterson's court's indulgence.
And, Your Honor, I would have an objection. I don't believe that the items that Mr. Cruz is asking this witness about have been tendered into evidence by either party. So I think that would be required prior to questioning the witness about the items.
Go ahead, sir. Yes.
Well, I disagree with that, Your Honor. I asked him a question about testing that he's conducted. The testing is within this witness's personal knowledge. He has gave a statement that is inconsistent with the report that he's written, and I'm introducing this report as a prior inconsistent statement.
All right. Let me see counsel at the bench for a minute, please. Thank you.
She can't just overrule the state. The state can't just do this every time they don't like where he's going with stuff. You brought this witness. Put everything in there. They should not be delaying the defense. Like, this is the state's witness. They brought this witness forward. Tough fucking shit if you don't like everything he says. Oh, this is where I get infuriated about stuff like this. If I'm a juror, I am looking at this going, why do they keep objecting? And why does she always have overrule the defense? There's no reason for to overrule this in essence, because he's just said something that is not in his report. So they might want to say, well, he needs to get more information. Oh, so frustrating. If you want to bring a witness in, then tough shit. Everything should be in. Also, in some ways, it's good for the defense. It's like, why are the state hiding this? And at least this has been done in front of them, which is good. Normally they get sent out. I'm trying to look at reactions.
Thank you. All right, ladies and gentlemen,
here we
I'm going
go.
to give you all your lunch break now. And so it has arrived. So if you'll go into the jury room and we'll present it to you, we're going to be back on the record in 40 minutes. And please don't discuss the case. We'll see you at 1 o'clock. Thank you.
They should go on record now or come back after lunch. Fucking Nora. I'll just see if they're going to come back. Now or after lunch. That is just... This is everything this case is about. We don't like where he's going with this, Your Honour. Your Honour, that he is spoiling our case, Your Honour. Your Honour, he's putting too much truth into evidence, Your Honour. Your Honour, I know we brought this witness into court, but we didn't expect the defense to go into this much detail, Your Honor. Your Honor, it's hurting our case, Your Honor. So frustrating. Right. It doesn't seem they're coming back because it's gone dark. So, right. Oh, I haven't got the energy. I'm just despondent, disheartened, all the things with this case. Bear with me. Well, it's going to be like 35 minutes. So I can't show you the defense opening because it's pointless, because it's like an hour and a half, 2 hours. I think it's 2 hours, I think. So, Oh, do you remember the, hang on, let me see this then. Do you remember that what I showed you last week? This is the Raleigh shooter who killed 5 people. Allegedly, this is the timeline of following when he shot the 5 people. Oh, actually, I won't show this because it's pointless, because it doesn't give you any context. I might show it another time. It doesn't give you any context, so Sorry, I'm so tired. I had 3.5 hours sleep last night. If that, I don't know if I had that much. I don't know. So I'm tired. Right, what else is there going on here now? Let me press play on this, make it live, because... Okay, that's now live. We're going to be back on record, I think, about 5 past or 10 past. So if you need a break, because now is a good time to go on break, because we've got plenty of time before all this happens. They come back, sorry, I mean. Oh, friggin' aura. I'm just trying to find something. Oh, hang on, I know what I'll do. I haven't got the energy anymore to even debate this trial. Let's watch something. Oh, do you remember right, I'll play this. This is the Indiana case. Hang on.
You were looking at the...
Let's do this again. This is Tyler Thomas, who killed, or allegedly killed, Haley Busby. Well, we know he did. Piece of shit he is. She's 17 years old, from Indiana. This is his booking footage being released. So let's play this. This should take us all the way up to the
man investigators say is at the center of one of the most disturbing cases to unfold across Indiana and Ohio in years. His name, Tyler Thomas. He's silent, expressionless, being booked into a county jail. Police say this man is an online predator, that he lured 17-year-old Haley Busby allegedly out of her home after meeting her online, picking her up, and then weeks later, he led investigators allegedly to the wooded area in Ohio where her remains were found. And now the question investigators haven't answered yet. Could this case lead to a homicide charge? And what are authorities now saying as this multi-agency investigation continues to expand? We're on the case presented by Law and Crime. I'm Chris Stewart. It's a story that began weeks ago in Indiana, and it's a story that spread across state lines. For weeks, the family of Haley Busby held on to hope, and for weeks, her community searched for her, putting up flyers and businesses sharing her picture, her name, and her story on social media. The search for a 17-year-old girl, Haley Busby, a smart, beautiful teenager who had plans to go to college. She was last seen at her home in Fishers, Indiana, which is a community outside Indianapolis. The search for Haley became a multi-state investigation. It crossed into Ohio, and the investigation centered on a 39-year-old man, a man that didn't have a criminal history. His name is Tyler Thomas. Police say that Tyler Thomas spoke to Haley online. They met in some sort of online gaming community. Police say that Tyler Thomas picked Haley up, and that's never really been in question when you look at this investigation, that he was the person that went to her house in Fishers, Indiana, and picked her up late at night. But what he said happened next is what law enforcement now is calling a flat-out lie. Tyler Thomas claimed that he picked up Haley at her home in Indiana and then dropped her off on the side of the road in Ohio. But that story fell apart allegedly in this investigation, and it led to a devastating update that Haley would not be coming home alive. Remains believed to be Haley's were found in a wooded area in a park in Ohio. A discovery that the suspect himself, Tyler Thomas, allegedly led the FBI and local authorities to. Now, Tyler Thomas, he's now in custody on charges of pandering sexually oriented material and tampering with evidence. Authorities say that additional charges are possible, and his attorney says that he expects that his client will face a charge of homicide. But now we have some new video. The booking footage showing the man at the center of these allegations, Tyler Thomas, being processed into custody in Ohio. This video, it's a long, revealing look at a man who authorities say is connected to this case and is the man who led them to the remains of the girl that so many people were looking for. Now, when you look at this video, it may be hard to tell who Tyler Thomas is, what his body language tells us, it's unclear. And with his attorney saying that Tyler Thomas maintains that he did not kill Haley Busby, one of the big questions is, where do we go from here? Now, this story, in some ways, it is a complicated story, and it's certainly a heartbreaking case that unfolded across 2 states. And it's really important that as we follow this story, we get the timeline straight of what authorities say happened. So this case begins in Fishers, Indiana, which is a suburb north of Indianapolis. And we go back to the start of this year, January 5th. You have 17-year-old Haley Busby. She is last seen by her family at her home around 10 o'clock at night. And it was a typical night. The family says goodnight, and that's it. But the next morning when they all wake up, January 6th, Haley Busby is gone. Now, she's reported missing to Fishers police. And here is the first crucial break in this case, because police in Fishers, Indiana say when they went through the neighborhood looking for clues, detectives identified an unknown vehicle in the neighborhood around the time that Haley disappeared. And that vehicle helped lead them to that 39-year-old man, Tyler Thomas, who lived in Columbus, Ohio. Now, for the next 2 weeks, Haley's family and community launched a massive search. Her dad, Bo Busby, sharing posts on social media every single day, photos, videos, and pleas for help. Pleas for information to help bring his daughter home. When you look at Fishers, Indiana, flyers were up everywhere. They were on businesses. People were making sure that the public knew what Haley looked like, just in case there was any information that could help bring her home. Happy birthday to you. Now, during this time, as the public was searching, police say they actually made contact with their person of interest very early on in this investigation. Within just a few days of Haley vanishing, they zeroed in on 39-year-old Tyler Thomas from Columbus, Ohio. They traced that suspicious unknown car in the neighborhood back to him, they say. So what does Tyler Thomas say? Well, he gives them a story. He admits that he picked Haley up from her home, But then he claims that he just dropped her off on the side of the road in Western Ohio, and that was it. He says he never saw her ever again. So police are focused on who they say is their guy, but at that point, they do not have Haley, and they don't have enough to hold Tyler Thomas just yet. Now, this case was initially treated as a runaway case before it was upgraded to an endangered missing juvenile case. But behind the scenes, the gears were turning across state lines. By January 16th, so 10 days after Haley Busby was reported missing, Columbus police detectives in Ohio joined this investigation. And they moved pretty fast because on January 21st, they got search warrants for Thomas's home, which is a house on Hunter Avenue in the Victorian Village neighborhood of Columbus, which is a very nice area of Columbus. And they got search warrants for his car that they believe Haley was riding in the night that she vanished. And very importantly, they got search warrants for his electronic devices. And that is when this case changes. Now, according to court documents, police say they found a cache, their words, cache of sexually explicit photos and videos of the minor victim, Haley Busby, on Thomas's phone. And they also allege that he tried to delete some of them. That is the immediate tangible evidence of a crime. Thomas is arrested, and he is charged with pandering sexually oriented material involving a minor and tampering with evidence. Now, that is a crime in many states that could be seen as something along the lines of having child sex abuse material on your phone. It is a very, very serious charge. But that is not all that this search turned up, because evidence in Tyler Thomas's car and also in the home allegedly placed Haley Busby at those locations, proving that Thomas's story about dropping her off on the side of the road in Western Ohio and never seeing her again, in police's words, it's untrue. Allegedly, let's just call it what it is. It was a lie.
Our detectives identified Thomas as the suspect she had left with. We made contact with him in Ohio, and he admitted to picking Haley up at her home. He told us that he dropped her off on the side of the road in Western Ohio. However, through continued investigations, his initial story was determined to be untrue.
But where is Haley? That was the question that law enforcement still had at this point. The investigation zeroed in on another location. Police say through technology, likely cell phone pings or financial records, they tracked Thomas to what they are calling a short-term rental property in Hocking County, Ohio, which is a rural county. It's heavily wooded, and it's south of Columbus. It's known for its hiking and for cabins. So much more rural area than Columbus. And you have the Hocking County Sheriff's Office. They're now involved in this investigation, and they believe this is where Haley was taken. And critically, they believe this is where she was killed. Now, with Thomas in custody in Franklin County, Ohio, where Columbus is on those initial charges, something significant happens. Thomas lawyers up. He hires a Columbus defense attorney, a man named Sam Szymanski. And after getting an attorney, Thomas cooperates in a major way. On Saturday, February 1st, authorities say that Thomas led investigators, local authorities, and the FBI to a location in another county in Ohio, Perry County, to the Wayne National Forest. That's where they say Tyler Thomas allegedly brought them to the remains of a girl in a wooded area off of a trailhead. And that girl was Haley Busby. That is who they believe the remains belong to. Now, the next day, February 2nd, the Hocking County Sheriff serves a search warrant on that short-term rental property, and they say that's where they recovered forensic evidence that, quote, may indicate a crime occurred there. Also on February 2nd, during a bond hearing, Thomas's own attorney, Sam Szymanski, tells the court and the media two big things. First off, that he expects murder charges to be filed against his client in Hocking County. And secondly, he says that Thomas maintains that he didn't kill Haley Busby. And that is where this case stood just days ago. You have this suspect who is cooperating to an extent. He knows, allegedly, where the body was located. He is not disputing that he communicated with her online, picked her up at her house in Indiana, then brought her to these locations in Ohio. But he's saying that he is not the one who allegedly murdered this girl. Now, since the remains of Haley Busby allegedly were recovered from that national forest in Perry County, there have been several critical updates that have come in shaping how this case could play out. So I want to start with this new video that we have in. This is the booking footage of Tyler Thomas. There's no audio here. It's silent, so you don't hear if he says anything to law enforcement. It's a pretty lengthy video, shows him every step of the way being processed in the Franklin County Jail. And in a case with so many questions, you do watch this and you just look for clues. You look for anything that could give you a sense of who Tyler Thomas is. Again, we're talking about someone here who did not, to our knowledge, have a criminal record. And it's just someone who people have had a hard time tracking down who he is and where he came from. When he was first booked into the county jail, his address was listed as homeless. And yet law enforcement say they searched properties where he was. One that was considered his residence in that nice Victorian Village area of Columbus, and then this other short-term rental in Hocking County, Ohio. And again, as you watch this video, it's hard to fathom someone like this man who has lured allegedly a teenager across state lines, who allegedly had explicit material of the girl on his phone, and who also led investigators to her remains. It is just hard to fathom people like this. Of course, he is innocent until proven guilty, and we'll see how the legal case plays out in all of this at this point. These are allegations. And when you look at this footage, it certainly sticks out just how calm this person is. How he follows instructions. He looks at the camera for his mugshot, and there's really no visible emotion, no anger, no breakdown. But this video, though, it's just one piece of the story. The legal facts on the ground have become even more grim. We have learned from the Hocking County Sheriff that Haley Busby's body had been dismembered. Now, this obviously is just a horrific, horrific detail, and it was confirmed to 10 TV in Columbus. It adds another brutal layer to this story, to this crime, and what this man is alleged to have done. Now, the initial autopsy has come back. That's being done in Licking County, Ohio. Now, that process, the autopsy, confirms Haley's identity through DNA, and it also determines the official cause of death. And those two pieces of information are critical when it comes to the foundation of that major charge that Tyler Thomas is expected to face in Hocking County, Ohio, the charge of murder. And the coroner says it could take 4 to 6 weeks to get the final autopsy results. So now I want to talk about where Thomas stands legally at the moment. So you have this bond hearing. The judge there set his bond at $1.5 million. And the judge added some strict conditions. If Thomas was somehow able to post it, and we don't know much about his financial situation, Thomas would have no internet access and no unsupervised contact with minors. And then his attorney, Sam Szymanski, has said that they actually have no intention of posting bonds. So Thomas will stay in jail. It's also worth noting the prosecution's strategy here, because they are holding Thomas securely on these very serious initial charges of having this child sex abuse material allegedly on his phone, while this murder case is now being built brick by brick. And the person building that case, the people, it's a coordinated effort. You have the FBI, you have multiple agencies that say that they are working together. You have all these counties that this case stretches across. The FBI says that there's no timeline yet for more information to be released. Just yesterday, the FBI's Cincinnati office issued a statement saying, quote, "We are all deeply saddened by the events and offer our sincere condolences to Haley's family. The investigation is being driven by the pursuit of justice for Haley." But they were very clear about just how complex this case is. They said, quote, "Due to the many locations and jurisdictions involved, as well as the ongoing nature of the investigation, there's not a timeline for when more information can be released. This is dependent on where the facts and evidence lead." They asked for public patience to, in their words, protect the integrity of the investigation and ensure a just outcome. Now, finally, in the midst of this tragedy, we have seen a powerful movement grow from the pain of Haley's family. They have launched a campaign for what they call Haley's Law. And this campaign has skyrocketed with more than 75,000 signatures, and it's now being echoed at the highest levels of state government in her home state of Indiana. You have the lieutenant governor of Indiana putting out this statement saying, quote, "As Hoosiers across our state continue to grieve over the senseless murder of Haley Busby, I urge the General Assembly to pass a new piece of legislation called Haley's Law. It's aimed at preventing future tragedies like this from ever happening again." Haley's Law focuses on two important points. One, creating pink alerts for missing persons and children when credible risk indicators exist, even if amber or silver alert criteria are not met. And then the second part of it is mandating predator awareness education in Indiana schools focused on online grooming, digital manipulation, and coercive tactics used today. We owe it to our children to do better in this area. So you have from unimaginable grief, a concrete fight to change the system and to protect other children now exploding onto the political stage and getting the support of people who are at the highest levels of government in Haley's home state. Joining us now to talk more about this case from Ohio is Judge Fanon Rucker, also an attorney. Thank you, as always, for being with us here on Law and Crime. Just a horrific case involving this young woman, Haley Busby, just 17 years old. Starting with the suspect here, Tyler Thomas. What he's accused of is horrific beyond comprehension. And he really has no criminal record. And that always just kind of shocks me that someone's first interaction with the legal system would be for something as horrific as this. Like, what do you make of seeing someone accused of being such a predator online and a murderer, among other things, and yet it's someone who's really wasn't on law enforcement's radar?
Yeah. Well, first of all, thanks for having me on to talk about this tough case. There's a lot of pieces to this, and I know that we're talking about he's currently being held on some charges, but we have to be clear that he is not currently charged with her death. He's charged with things that I think were designed to hold him while they continue to investigate. Now, as you suggested, what he's being accused of, and we're suggesting the implication that he took this young lady from another state, something potentially sexually happened based on the possession of the child pornography charges that he's facing, and now she's found deceased, and he led the law enforcement authorities to her body. So there's some implication that more charges are coming. And you say that he's got an online profile, kind of as a predator, and this is his first offense. Well, we used to say on the bench all the time, and I used to tell people standing in front of me, just because it's the first time you're standing in front of me, it most certainly does not mean that's the first time you've committed offense. In fact, the likelihood is by the time someone shows up to court on something very serious, it's because they have evaded enforcement authorities for some time, as they did other things that family and friends were aware of that ultimately were revealed and led them to be criminally charged.
And it seems like he has such a, I don't know if shady's the word, but it's, he was listed as homeless when he showed up at the Franklin County Jail. But then there's a very nice home in Columbus where they say that he was living. He also had a short-term rental in Hocking County, and then he's going to face charges in that county south of Columbus. So there's definitely some parts of his past that will be looked at as this goes on. His lawyer has said that he led law enforcement to the body of Haley Busby in Perry County, Ohio, which is, I guess, neighboring to Hocking County, knowing that he had what has been reported as sexual videos of this young woman, child sex abuse materials, the term that I was looking for there. And then along with that, he leads them to the body. And yet, at the time we're recording this, and it's been a couple days since that development, he hasn't been charged with murder yet. What's the process to get there? The evidence that you need to have, even with those things, to be able to put that charge on him?
Well, it's certainly not unusual when large cases are brought that when there's a suspicion of a greater offense, that law enforcement officials, prosecutors, will charge cases that they can absolutely establish at the time that they charge it and say, look, judge, we have this currently. We're still investigating this, but we're asking for a high bond to hold this person while we continue to investigate, collect evidence, and form everything that we need to bring a very strong case for the higher charge. So what's the risk here? The risk here is that they bring a murder charge, for example, or they bring a kidnapping charge, and then his lawyer comes up with some information that calls that into question. So now, before it goes to the grand jury, there's a question about whether or not that charge can stand. So that person now is released while they're continuing to investigate and gather evidence. No, the safe thing for law enforcement to do is to charge charge some serious information that they have found. And apparently they did a search of his home and they found some of this very serious material. That's enough to justify some of those charges that can establish probable cause and get past a motion to dismiss. and justify a high bond while the investigation continues. Because right now they're poring over the remains that were found, the autopsy being performed. Certainly they're interviewing witnesses, neighbors, perhaps co-workers or other individuals. They're looking at those cameras from Indiana, where his car apparently was seen, was how they linked up the Indiana case to the Ohio case. They're looking through all that. So when they bring that murder charge, if they do, there will be quite a bit of evidence that will withstand the scrutiny of a dismissal.
So he's facing this charge, which in a lot of ways, they looked at his phone. They say there's child sex abuse material on that phone. So that seems incredibly damning for him. He's being held on a $1.5 million bond for those charges right now. But then his attorney says that he has no intent of posting bond. I don't know if that means that he actually has the financial means, like with a bail bond, that he would be able to get out of jail. But what is the strategy for a defense attorney to come out and say that, to say, hey, he's not going to contest in terms of posting this bond and then trying to be out ahead of time, even though he's not charged with murder at this point?
You know, when I heard that statement, a couple of things came to mind. First was what you suggested, maybe that he doesn't have the financial resources to even try to gather together $1.5 million in order to be released from jail while this case is pending. Or in light of the potential forthcoming more serious charges related to this young lady's death, he may be anticipating, what's the point of me posting bond, because I know that there are heavier charges that are coming. The other thing that I thought of was the question of whether that is evincing a guilty mind. You know I did wrong. I mean, we have right now, what we know is that this young lady went missing. There were questions about whether she was in Hocking County and her body was found in Perry County in Park. And he led them to her body. So perhaps, and again, pure speculation, perhaps the statement he's not even trying or has any indication of posting bond could be part of his, of a guilty mind that I know I did something wrong here. And so at this point, I'm not even going to fight having to sit down and face these consequences when they come. But again, that's pure speculation, but that's what came to my mind when I heard that.
And then as a judge, you know, and in this case where it's anticipated that there's going to be a murder charge coming, that this case, it's already serious based off what they say they found on his phone, but we know that it's going to go to that level. As a judge, how much does that factor into the way that you approach this case at an arraignment or a first appearance on these unrelated charges, knowing that the prosecution believes that they have a very strong case for murder coming, but that's not something they've charged him with yet?
So I remember a well-known Ohio, Cincinnati serial killer who was in front of me. I actually signed the warrants when they were seeking to go through his property. And at the time that I signed the warrant, they had a lot of information about several individuals who this person allegedly had killed. I say allegedly, then he was subsequently convicted of killing these young ladies. But at the time that they first charged kidnapping and possession of stolen items, because he had on him, when they initially stopped him, items belonging to one of the young victims. And so, but when they brought him to arraignment, they mentioned, Your Honor, we are still investigating. We have reason to believe that this individual has been involved in a number of homicides. And the information in the search warrant is giving us additional reasons to believe this. We're asking for a very high bond based on our suspicions, not even based on the charges that they brought. I mean, they did ask for those charges they brought for high bonds to be given. But the reason for the request for a high bond was, number one, because of the seriousness of the allegations of what he was charged with, but also because of their desire, their concern, their fear for public safety if this person was released, while they were continuing to gather evidence for those several homicides that he was involved in. So it's not an unusual strategy, but, you know, it's up to the judge 100% whether or not to accept what evidence law enforcement is arguing for and the prosecutors are asking at that time to justify a bond that will, in fact, keep someone while they continue to investigate a case.
And then looking at the jurisdictions that are involved in this, because you have Hocking County, he apparently had a short-term rental there. It appears that this is where law enforcement believe he allegedly took the life of this young woman. Her body was found in Perry County, Ohio, in a forest there. So that's another county. And then he was living and apparently brought her, allegedly, according to law enforcement, from Indiana to Franklin County, which is where Columbus is, where he had a home. So you have 3 different counties here, not to mention Indiana. And all those counties could be places, at least from what we've been told, where a crime was committed. How does the prosecution of a case in Franklin County differ from what it may look like based off the charges that could be coming in Hocking County?
Yeah, it all depends on where the evidence leads. I mean, like you said, we know that right now she was in Indiana, Fishers, Indiana, where she was relocated from. Will there be charges there based on her leaving or?
Right, shut the front door. Is this Jonathan? Because there's no one else that says Dilly Willy Banana Fana to Philly. Jonathan, is that you, digital nuisance? Because if it is, hello, sir. We have all missed you. If it's not you, then ignore it. But I believe this is you, Jonathan. It is you. It is you. I believe it is you. Let us know if it is you. Why have you changed your account?
Being spirited away or potentially kidnapped. I mean, you don't know what will be produced by way of evidence from that investigation of where this all started. And then when you come to Ohio, 3 different jurisdictions that have potential crime scenes. It all depends on where the evidence leads. Was her life taken in Franklin County? Is there evidence there? Is it evidence that she was assaulted brutally in Franklin County and then transported to Perry County and then taken to Hocking County? Or, I mean, it all depends on where the evidence stands. We don't know right now what the evidence will show as to where this young lady's life was taken. We don't know. We have no idea. It could have been in the park where she was ultimately found. Or it could have been that she was...
Well, hello, Jonathan, and hello, Amy. How are you doing, Amy? Hope you're doing well as well. Nice to see you, Jonathan, as well. Not seen Jonathan for like over a year, probably a year and a half, maybe in this chat, that is. Nice to see you both here. Hope you're doing well, John. Are you back, or what's happening? What's the story with you? Are we going to see you more often now, or are you still going to dodge us? What's happening? And Amy, I hope you are well as well. Hope everything's going well with you, Amy, and that you're ready for the weekend. We got a little bit left on this, people, and then we'll get back to it.
Transported there after her life was taken. Another thing we talk about that he has not been charged, we also don't know right now, because the evidence is simply not revealed due to investigation, were other people involved here? Was he just someone who was aware of what was going on, but wasn't the actual person who may have committed these offenses, even though there's concern about his online profile and some of the things that they found on his phone? That's just information that's just not known. And a hasty charging or accusation against him in this regard, other than what is known that he possesses, would also be another reason that law enforcement has to be cautious before they bring that charge.
With the charges he's faced right now, they say that they looked at his phone, they find allegedly child sex abuse material. So that seems to be a very strong case against him on that charge. And if that was the only thing he was facing, that would still be a very, very scary situation, in terms of what he's accused of doing, but also very serious charge that he would be facing if that was it. But he's obviously facing potentially a murder charge here, which could put him to prison for the rest of his life, and then maybe the death penalty. We'll see if that comes into play. He also, because he was talking to a girl in another state online allegedly, and that could be a federal charge, right? Like, and how often in those cases do you see the federal government look and say, well, we could charge him with this and make this a federal case, but because Hocking County has really specific evidence for the highest charge that there is of murder, that we don't need to get involved?
So I thought about the federal implications of this. Also, we know that transportation of individuals across state lines can be considered, in certain instances, kidnapping that would implicate federal criminal statutes and lengthy sentences. My experience in my first job during law school was actually clerking for 2 federal magistrates. I'm working in the federal court system, handling criminal cases or observing and writing reports and recommendations on criminal cases. Over the years, as a prosecutor and as a judge, my observation has been that federal authorities generally get involved in these types of cases if there is not there's not confidence that the state penalties or the state outcome will be sufficient, or if there is suggestion that this individual was involved in a greater number of offenses than just the one that we're talking about. So, for instance, when he's talking to other young ladies online, how many other young ladies was he talking to online? How many other states are involved in this conversation? Did he transport anyone else? You know, is there evidence perhaps that he was involved in sex trafficking, for example, or something of that nature? If the fingers begin to stretch in that way to reveal some information that leads federal investigators to believe that it's larger than a single incident, then it increases the likelihood that federal investigators and federal authorities would get involved to charge.
And then just lastly, Judge, I mean, I can't imagine what her family's going through and the strength that they've shown to be public, at least on social media, and as she was missing and spreading the word throughout their community. And then now in the wake of her death, pushing for something they want to call Haley's Law. And part of it is having more education in schools so people understand who they may be talking to online, which I think is really important. But then the other part of it is the night that she goes missing, this wasn't an Amber Alert because it wasn't a kidnapping. I mean, she was 17, so she's, under the age of 18, but, was talking to this person online and then gets into the vehicle. And then she was characterized as a runaway or missing. But obviously there was more to the story than that. And the family believes, and it seems like it's getting some political support in Indiana, that there needs to be what they would call a pink alert, something that is, it's not an Amber Alert, but it could have more of that type of messaging when you have a situation where, yes, she may have gotten voluntarily into a vehicle of somebody who she met online, but the circumstances are certainly far more concerning than just someone who had run off. I guess at this point, how do you look at the alert system and the way that could actually play out?
So it actually had a case a couple of years ago involving a young lady who was in a similar situation. And each state has certain parameters of the use of their alert system. And Amber Alert is not the only level of alert in Ohio, but all of them have certain requirements in order for that alert system to be used. There is a lower level alert where there are certain characteristics of a person. If they are someone who has potential medical issues, if they are considered under 18 but over 15, I mean, in that window, if they are potentially with someone that there is a risk of physical harm, those take it outside of the Amber Alert. It's something less, but it still is a flag to law enforcement that we need to take some affirmative, quick steps to let the public know that this person is someone to keep an eye on. An Amber Alert is a little more urgent. And the pink alert, that's why they call it a pink alert, it's like, hey, this is important material, but it's not, we can't say that this person is immediate Jane. We can't say it for sure, but we do at least want people to look out just in case there's something that happens here that we need to be involved in. I think it's important. I think it's good. I think it's tough because of the amount of resources that are needed in order for these alerts to function properly, and considering, and it's horrible, the number of young people, particularly the number of young ladies in urban communities who go missing every day and who many of them are not found. Some are considered runaways. Some are victims, unfortunately, of parent kidnapping, but others, people don't know how they're going missing. They just have gone missing. But law enforcement doesn't generally look at it as an urgency because of their age or because of how it was reported that they're no longer with their loved ones. So I'm certainly an advocate of whatever process is available to ensure that people get back home. But I understand the practical issue and difficulty of stretching resources to deal with all of the individuals that actually may be impacted.
In this case, it's just, it's such a nightmare in so many different ways. And we'll see how the prosecution now of Tyler Thomas in Ohio, how all of that plays out. Judge Fernand Rucker, thank you as always for taking the time to be with us on Law and Crime. Very tough case here, but we really appreciate you helping us understand some of the context to it.
Okay, so that's that. We can take that down. I could take that off now. Hang on, let me put this back on because it should be back in court any minute. The lights are on. Oh, here we go. Let me just go back and check. So just so everyone knows, Digital Nuisances is Jonathan. Jonathan is one of our mods. He's just been missing in action for a while. I've not seen him. Obviously, he's been in other chats and stuff like that. I know that other people have been speaking to him, but I've not spoken to him for ages. If you're back, Jonathan, what I'll do is I'll switch out. You can't grow weed anymore now. So for those that don't know, Jonathan speaks a lot of nonsense, but also Jonathan is very well liked in the chat. He just hasn't been here for about a year. What I'm going to do is switch you, Jonathan. If you've lost your account, what I'll do is, because I still got you down as a thingy-majig, but I'll just change it because you still got access to everything. So what I'll do is I'll cancel your other account and put this account on instead, so that you got that, because you still got access to everything. So I'll just switch you out. Anyway, the court's back, and I'll cancel the other account, Jonathan, which I can do now whilst we wait. Everyone's going to think you're a new mod. He's not a new mod. He's been a fucking mod for too long. He just pissed off for a while. Right, I've just cancelled your account, Jonathan, so... Where's the... Maxi Lovely's hands for yours. Okay. Oh shit, maybe I'll cancel your new account. Fuck. I did. Hang on, let me do it again. I cancelled your wrong account.
Do we have your witness? Mr. Peterson. Well, I want to do some things outside the presence of the jury, so you can get your witness then. Okay. Yeah.
Done again, Jonathan. Right, I can zoom this forward.
Thank you. Examine this witness. There was some discussion at the bench about Mr. Cruz wanting to use a document to examine this witness under 24-6-613. The state asked, pursuant to that statute, certainly, to get a copy of what you were using. And then the state made an argument pursuant to 603. To 403. And so because of the state's argument about 403, the balancing test, I wanted to go through this moment outside the presence of the jury before I make a ruling. And so, Mr. Cruz, I'm going to let you examine this witness with that moment. And the law requires that you allow the witness to, I'll just use this language of the statute. The witness is first afforded an opportunity to explain or deny the prior inconsistent statement, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement or the interests of justice otherwise require. So before I get to that portion of the statute, I want to hear what we're talking about because the state has made a 403 objection. So you may proceed, Mr. Cruz. With the question you were going to ask him. He answered a question, and you wanted to attempt to impeach him with a prior inconsistent statement. The state objected based on 403 grounds, and so that's why I'm conducting this hearing outside the presence of the jury.
Excellent. So just to let you know the process that was taking place when the objection was lodged, I was about to mark this as defense exhibit, I believe, 32.
You asking if I have it, defense exhibit 32?
Oh, no, sir. I was asking.
Not yet.
Oh, I'm sorry.
Not yet.
Okay. So I was going to mark this
Okay.
as defense exhibit
All right.
32.
Okay.
And my next question to him after I mark this as defense exhibit 32 was going to be in your March 19, 2001.
Well, actually, before we even get to that, Mr. Cruz, you may not need to get to that moment. Let me ask you this question. Let me ask counsel. Now that you're going to mark it as an exhibit, it kind of takes a different turn.
That's where the objection came.
Okay. So, well, it did because you weren't tendering it, and you don't necessarily have to when you're dealing with a prior inconsistent statement.
I actually was going to admit the prior inconsistent statement into evidence,
Okay.
but I typically mark it for purposes of the record.
Okay, well, that's fine. Well, let me ask this question of the state first. Based on that he is going to offer it into evidence, do you have any objection? Do you have any objection to that? I mean, based on the conversation counsel had with the court at the bench, the reason I'm doing this outside the presence of the jury is because of the 403 argument. So is there any objection to the tendering of that document? Is there going to be?
I'm sorry, Judge.
Is there going to be any objection to the tendering of that document?
I think that there would be, as it relates to examination regarding a hair found in a wallet. And the reason is, Judge, and I would, if the court allows me under 24-1-104, I think this would be a matter of a preliminary question. And I can state in my place that pursuant to documents that are in discovery and produced to Mr. Cruz, this item actually didn't come into, the item was not believed to contain any hair at the time of the initial processing of the crime scene. It was returned to the Baker family, who then, over 2 weeks later, on February 8th of 2001, brought the wallet back to Athens Clark County Police Department and relinquished custody to the Athens Clark County Police Department. And then subsequently, in a transcript of an interview between ACCPD and the Baker family in May, Miss Baker's father, Mr. Lindsay Baker, stepfather, but the person she considered to be her father, Mr. Lindsay Baker, indicated to police that we found a hair in that wallet. What have y'all done with it? And so I imagine what Mr. Cruz is going to question the witness about is whether or not that hair was tested. And so I guess our objection under 403, or it would, our objection pursuant to 24-1-104 is there's been a lot of discussion about chain of custody as it relates. Now, in this particular case, circumstance, I think there is a legitimate concern about chain of custody and the manner in which it came into the possession of law enforcement and GBI, which is why additional testing was not done. If testing had been done, it still probably wouldn't be admissible in a legal proceeding due to the fact that it came from a wallet that had left the crime scene and been in the possession of other parties for fairly extended period of time. We're not talking about an hour or something like that. So.
Okay. All right, thank you. Mr. Cruz, do you want to respond to that? And then I'll let you ask the question. I may have some questions for you. Do you want to respond to that?
I just want to make sure I understand the objection was to 403, but also chain of custody. Am I understanding that correctly?
Well, I'm not going to put words in Mr. Yellman-Chili's mouth. I can tell you what the court thinks it is, but go ahead.
Foundation for admissibility of the evidence that he is questioning the witness about. I think if we are going to talk about evidence, it needs to be present and tendered in the courtroom. Now, it could be that Mr. Cruz goes through the process of tendering that evidence in some manner. It just hasn't been done yet. So, I mean, I guess my objection's on a couple of different grounds.
All right.
Yeah.
Go ahead.
So I understand foundation is a ground, chain of custody is a ground, and 403 is granted. If I could ask clarification from the Honorable Court or Mr. Yalamachili, as far as 403, what particular ground do I need to address?
You can ask the state.
Well, Your Honor, when we were at the bench, I think my original objection was actually to the predicate requirements of a prior inconsistent statement not having been met, because I think Mr. Peterson testified that he believed that it had come from a purse, and Mr. Cruz had indicated it had come from a wallet, and we stated at the bench, so it was our belief and our understanding of the evidence, it actually came from a wallet that was inside of a purse, so it wasn't necessarily something inconsistent with Mr. Peterson's testimony.
All right, so in regards to the foundation of a prior inconsistent statement, Mr. Peterson, I asked him, was it a pubic hair? He said it was a head hair. I asked him, was it on a wallet? He said it was in a purse. It's semantics, but my particular question asked about a wallet. His report references a wallet. It's not reference a purse. So the foundation has been laid for a prior inconsistent statement. He was confronted with the statement. Well, was about to mark the exhibit to confront him with the statement before the objection came about. But once I've given him an opportunity to, or once I've confronted him with that statement, if he says no, it's still a head hair, or no, it was in a purse, at that time I would tender this into evidence as impeachment material. In regards to the chain of custody, this isn't a chain of custody issue. Chain of custody applies to fungible evidence, not to documents. So chain of custody would not apply in this situation. In regards to the state's argument, as far as I need to tender the hair in order to impeach Dr. Peterson, in regards to the hair, there is no case, no law that exists that would support that proposition anywhere, probably in the United States. And lastly, in regards to 403, Your Honor, I still wasn't 100% clear on the exact ground of 403. So I would ask for the 403, just look, the specific grounds for 403.
Confusion of the issues and misleading the jury.
Okay. In regards to confusion of the issues in this case are whether or not Mr. Faust committed this crime. This evidence is evidence either in support of Mr. Faust committing the crime or evidence that goes against Mr. Faust committing the crime. The anticipated testimony from Mr. Peterson's report is that the hair that was on the wallet was a pubic hair, and it was of Caucasian origin, or the way I asked the question, it was not a African American hair. I had no intentions to ask about testing the hair. I now do, but it's relevant. It won't confuse the issue because it goes directly in line with our theory that Mr. Faust was never in Ms. Baker's home. And this testimony supports that materially, Your Honor.
Okay. Mr. Cruz, let me ask you this question. Well, first, I'm going to let you ask him about a prior inconsistent statement and give him the chance to respond. And then I want to talk to counsel about something else.
Sure.
So you may go, because I don't agree that you've established that you have the right to present evidence about a prior inconsistent statement yet. So if you believe that's going to be the case, I'm going to let you try that.
Sure. May I mark the exhibit, Your Honor?
You can for this particular purpose, but we're having a hearing outside the presence of the jury.
Sure.
So just go ahead and ask him the questions you were going to.
Yes, ma'am. Thank you for your patience, Mr. Peterson. You obviously know where I'm going with this line of questioning, but you examined the hair found on Ms. Baker's wallet. Is that correct?
Yes. I had earlier said purse, just from my recollection, but by looking at the report, it does reflect hair from a wallet.
Okay. And would you agree that it's also a pubic hair?
No.
Okay. Mr. Peterson, in your report dated March 19th, 2001, did you state, court's indulgence, I'm mistaken. You are correct. You are correct. Okay.
All right.
So we are clear on the wallet portion, and I was incorrect as far as the pubic hair. Please forgive me.
All right, thank you. So let me just respond then to, well, before I respond, unless Mr. Yalamanchili, since it's your motion, do you have anything else you want to say about your argument about this information under 403?
No, Judge.
Okay. Mr. Cruz, do you want to respond to their argument about this evidence being violative of 403?
The proffer that I gave to the court, I would stand by that.
Okay. All right. Thank you. So both parties have given a proffer about what this line of questioning is about. And I will say this, I agree with the state that this is violative of 403.
Yes, ma'am.
Because of the proffer that the state has made about the circumstances surrounding the testing of this purse, wallet, several weeks later, under the circumstances that they have described, is a moment, I would say, of profound confusion, possibilities for the jury. And so I'm going to grant the state's motion with regard to the concern about 403, and I'm going to instruct you not to go into that area of questioning with regard to the testing of this purse, wallet, this line of questioning. I'm going to instruct you not to go down that line of questioning.
But don't touch on the wallet to make sure.
That's correct.
Yes, ma'am.
All right, thank you. All right, I'm going to bring the jury in because I want everybody to be mindful. It is 1:20, and we are supposed to be ending at 2:30 today. As best we can, there's a juror that's going out of town. This may be our last witness, but I just want everybody to remember, we're running behind. It's 1:20. So, all right, anything else? You ready for the jury to come back in, Mr. Cruz?
Yes, ma'am.
All right, state ready?
Yes, Judge.
All right, if you'll bring the jury in.
Mr. Peterson, you would agree that there was pubic hair found in Ms. Baker's left hand?
Correct.
And that pubic hair was tested against the known sample of Mr. Melton's head hair. Is that correct?
No, they would only be compared against pubic hair.
So it's compared against Mr. Melton's pubic hair?
Yes. I believe that's correct.
But he's still going through his report just in case.
All right, in your report, did you write microscopical examination and comparison of the question hair removed from items? Let me ask you this before I answer that sentence. Item 10, we can agree, is the hair from Ms. Baker's left hand.
That's correct.
Okay. In your report, you wrote microscopical examination and comparison of the question hair removed from item 10 with the known head hair of item 21, 22, and 23 reveals they have dissimilar microscopic characteristics and therefore could not have originated from the same source. Is that fair?
Yes.
Okay. And item 21 is listed as the head hair of Chris Melton. Is that correct?
Correct.
Okay. And I believe on director testimony was that hairs that grow in different areas have different characteristics. Is that correct?
Yes.
Okay. Can you show me the report where you tested item number 10 against Chris Melton's pubic hair?
Don't believe that's in the February 2nd report. I think that's in a subsequent report.
Sure. Can you show me?
I wish you would show me.
Sure. And was seeing all of your reports refresh your recollection?
Well, I have two reports, States Exhibits 136 and 137.
Well, Mr. Peterson, you just asked me you wish that I would show you. I'm willing to show you. Would reviewing your reports refresh your recollection?
Yes.
Okay. I am going to show you or let the record reflect that I'm showing you your report from March 19th, 2001, May 16th, 2001, October 11th, 2001, February 2nd, 2001, February 27th, 2001, and that's two separate reports, and March 19th, 2001. If you'll take a look at these documents to refresh your recollection and let us know once your recollection is refreshed. May I approach? To make the record clear, and just so there isn't any confusion, to make the record clear, I am asking about the pubic hair found in her left hand being tested against Mr. Melton's pubic hair.
Well, if that hair from the hand, which was eliminated microscopically, the victim's own hair, if there had been another pubic hair sample submitted, then it would have been identified as also being consistent.
The answer to my question, my question is, was the pubic hair found in Ms. Baker's left hand tested against Chris Melton's pubic hair?
Well, the characteristics of his hair are dissimilar than those of Tara Baker's hair.
Please.
Are you asking me that there should have been a recorded statement saying that the hair was eliminated, as opposed to my testimony today that it is not similar to Tara Baker's pubic hair and therefore could not have been his?
The question I'm asking is whether the pubic hair found in Ms. Baker's left hand was tested against Mr. Melton's pubic hair. And if you can, yes or no?
It was not similar to the pubic hair from her left hand.
That doesn't answer my question is, and maybe I'm saying that wrong, please forgive me. And if you can answer yes or no for me, please do so. You had Mr. Melton's pubic hair, is that correct?
Yes.
Okay, and pubic hair was found in Ms. Baker's left hand, is that correct?
Yes.
Okay. Was that pubic hair of Mr. Melton's ever tested to see if it was the pubic hair in Ms. Baker's left hand?
It was indirectly eliminated because a comparison of the knowns also took place to know what their characteristics are, and they were not found to be similar, so it could not have been consistent with the hair from the left hand.
Is that a no?
Sorry?
Is that a no? Is the answer to my question a no?
The comparison does not have to be a direct comparison. The characteristics of the two known samples are not the same, so they both can't be consistent with the hair that's only consistent with hers from the left hand.
And I thank you for that information. That is great information, but I'm asking you a specific question. To my question, is that a yes or a no? Was it tested?
Yes.
Can you show us the report?
No.
Okay. No more questions, Your Honor.
Any redirect, Mr. Yalamanchili?
No, Judge.
All right. May this witness be excused?
Yes, we ask that he is.
Any objection from the defense?
No, ma'am.
You are free to go, sir. You may call your next witness.
Your Honor, could we approach?
You may.
The most simplistic question, yes or no, can never answer it.
We have an hour. Yes, sir.
Why is he so unhappy? He's pissed off now for some reason. Maybe because he hasn't got a witness as well. I don't know. But why can't they, with these witnesses, just answer yes or no?
All right, ladies and gentlemen, believe it or not, we have finished early today. So, particularly the person going out of town, yay. All right, so I'm going to release all of you today, obviously at 1:30, and ask you to return again on Monday at 9 o'clock. Obviously, in the meantime, my instructions continue to apply. Please don't discuss the case with anyone. Don't do any independent research. Don't look on...
We'll see if they come back in court. If not, I'll end the stream, but yeah.
All the things that we've discussed. Does anybody have any questions for the court? Don't go to any locations that have been discussed, of course, by any testimony. Anybody have any questions for the court before I release all of you? I appreciate your patience this week. It has been a productive week in terms of a lot of things we've gotten through. I appreciate your patience. I know you go in and out of the jury room a lot. That's certainly common in a trial, but I know that it is sometimes, it could be aggravating for you to get up and get down and get up and get down. I know that. So I appreciate your patience with that. Next week, we're going to hopefully have more of an opportunity to have a normal lunch break. Like I said earlier, you can go outside and stretch your legs and things of that nature. We'll have to see how the timing goes, but that would be my plan. So with the thanks of the court, you're all free to go, and we'll see you Monday morning, 9 o'clock. Thank you. In this courtroom.
We'll see if she comes back or not. So she's not going anywhere, so she might. There might be some arguments. They should utilize this time for any motions and stuff like that, if there is any. Hopefully the end of the day. I'm tired. I've had enough of this fucking trial for 1 week. Everybody, yeah, rock your body, yeah, rock your body right, just like Sherry last night. Sherry Berry rocking the body last night. It's very odd that the judge is overly super happy with the fact that it's a short day. So they had to have a short day anyway. They were finishing at 2:30 anyway. So the whole plan was for it to be short. So I think everyone's just relieved to just be able to reset for the weekend. You know. So yeah. It's I think a street. I need to change that, hippie chick. So it comes up as streets. There is a way of doing it. Hang on, let me stretch this here. Where is it? Commands. I command you. Street. So if I do that, advanced, I can also put in streets.
Everybody gone? All right. Court is adjourned. Thank you.
Right, I just changed it.
May I see counsel, though, at the bench off the record? Thank you.
I've just changed the hippie chick, so you should be able to do it, and same with roses as well.
So, give me about...
Confirm. There you go. So now, Sherry Berry was rocking it last night. So if we put in streets now, hippie chick, it will work. So anyway, there you go. Spacey Stacy, the nosy bitch. She's back and she's doing it. So there you go. You got it. Right, everybody. That is it. Thank fuck for that. I've had enough. It's been a pleasure. I'm so glad to see Jonathan back as Digital Nuisances. As I say, if you think Bad Daza was fucking bad, wait till you see him start. They're just as bad as each other. I would say probably Bad Daza's more sexual though. But yeah, Jonathan's dark. But it's a pleasure to see you all. I really do thank you. Go Pats for Sunday. They are back in court at 9 on Monday. I'm probably going to start about 9:30, 9:45 because they take so many breaks that I'd rather come up from behind. You know, ladies, yeah? You'd be super busy on the streets. I have not been on any streets. I'd rather stay at home, oblivious to the streets. But yeah, I'll probably start later because we can zoom through stuff then because they just take too many breaks, you know, and it's just too much. So I just rather go from behind. Dave, I'm gonna mute you, Dave. Delete you from the channel, Dave. But yes, with all that said, thank you very much. I'm not sure who the Hawks are playing, but good luck to them. With all that said, I do wish you all a very merry weekend. And yes, I shall see you at some point, probably 9:30 on Monday. Let's say 9:30. We'll probably start stream at 9:30. Start this whatever at 9:45. Did I mention I got divorced? Oh, Jonathan. Oh, and good luck to you worrying about Rocky. Right. I know, it's safer at home. Jonathan, come back Monday, we'll talk about your divorce. Fuck's sakes. Okay. Right. Take care, everyone. And I don't know how to end the stream. Here it is. Here.